Wait.
Yes, yes.
When I'm praying for listing of a new matter motion tomorrow, of which the connected matters are also listed tomorrow. Lordship, because there was a post matter wherein I was given a free chip, clean chip, and thereafter they went in for a de novo proceeding against me. A transfer and all matters, Lordship, were considering. Now, in the de novo proceeding, I've also been given a complete clean image. But still, they are suspending the issue. The suspension order is under challenge. Please solve it tomorrow. The connection matter.
The other matters are listed.
Yes. 31 to 33, I presume.
Please, your lordship. My lord, in item 54, my lord, we have file and reply. My lord, this may come along with the reply after vacation, my lord. We have filed it on Monday. 54, my lord.
4.
Yes.
They submitted by the council consider that the joint affidavit has been filed yesterday.
Monday, my lord, 15th.
How the same is not connected to the case report. Submitted that. Then the registry will place out the affidavit and basically report immediately after vacation on the day.
I need to mention for listing one. It was listed on 9th of June, lordship.
9th of
June. On that date, your lordship.
admission matter.
Admission matter.
Let it
This
be after.
regards family, the compensated family pension person.
Can it not come after vacation?
And it's some urgency. There's no
Urgency.
nothing has been paid, lordship, by the
Huh?
respondent authority to the
Huh?
petitioner.
But
After his death, the death of his husband, her husband.
you should have mentioned it immediately. Why did you wait for today? 1 week later. The matter was not listed. You should have mentioned it immediately.
And the lordship Monday or Wednesday.
Monday, Tuesday, we can't because it is a motion day. It will declare to be a motion day.
Any day before vacation.
Before vacation, not possible. Tomorrow and day after, 2 days. One tomorrow, we'll get it tomorrow. Right?
Lordship,
Tomorrow.
okay.
Lordship, I am also praying for this thing for admission, Lordship. On last day, Lordship.
After vacation?
No, Lordship. Yeah.
All right, tomorrow.
Tomorrow.
Okay, item 34 and 36. The consider other side. My payment that come up after vacation.
34 and
36.
34, 36 on the request of Mr. H. Gupta, matter stand referred to be listed after 3 weeks.
It's a date for the matter. Got it mentioned and got it.
So why are you agreeing to the adjournment?
That's only the praying for a date.
It was fixed on 12, my lord.
It was mentioned for the 12.
Then?
It was not listed and we made a mention for 7.
What is it for?
Arbitration.
Why? The pleadings are complete.
Yes, sir. Yes, sir.
28th of July.
Item number 21 and 23, madam, beta becoming after.
21 and 23 on the submission made by the council to the petition. These matters are becoming infructuous. Accordingly, the same stands dismissed as infructuous. The interim orders, if any, stand vacated pending either.
One big question regarding the challenging of the advertisement of the direct to women and child development.
Admission matter. It will be after vacation.
Can it be before vacation? There is an urgency.
All right, tomorrow.
The new motion matter cited
When was it filed?
yesterday.
Come. Either if not tomorrow, then Monday,
Friday.
Friday. But you have to clear the defects and all that. Only then it will come. Friday is subject to clearing of defects.
Okay.
Yes.
Please, your lordship. Lordship, this is with regard to item number 28. Lordship, this is a matter pertaining to the employees of High Court, and there is a bench which has been assigned for this matter.
Yes.
So this matter may be listed before the appropriate
But
bench,
that we
lordship.
can't say. We say that the registry to examine item number 28
Yes, your lordship.
is submitted that these matters pertain to file to some 28. You wait for the matter to be called up. We'll
Lordship,
pass
it
orders.
is a notification,
You wait for the matter to be called up. We'll look into the matter and pass orders. Right?
Lordship.
Yeah, Lordship. WBC 239/26, man, is supposed to come on to them, as speaks on 8/6, man,
Not listed.
not figure in the list, man.
What matter is this?
That is, man, suspension, man, information of the acts from the department.
For admission matter.
Lordship.
Admission or motion?
Motion matter, madam, Lordship has passed an order.
Matter is at the stage of motions.
Yes, asking the two information from the respondent whether the sufficient allowance is paid or not, whether the charge sheet
Well,
was
let it come on Friday.
madam,
Friday?
Friday.
Provided it is a motion matter. Is it motion or admission?
That probably next. But Lordship has passed an order, madam, asking two information from the respondent.
Verify motion will be Friday. If it is not motion, then it goes after vacation.
Regarding the sufficient allowance and all, that is why this is Lordship on 8/6 fixed on early date, madam, 17/6. It was fixed on 8/6, madam. Come on 17/6. Allowance not paid, madam.
Okay, tomorrow. Tomorrow.
Tomorrow.
Yes.
Take to mention for listing matter relating to pension.
Pensionary after vacation. 27th or
Yes, sir.
20, it's for admission.
Admission.
29th July.
One another similar pair.
29th.
Madam, I'm paying for listing.
29th July.
Legal views and the has been received by the department. So they need some more time to examine the
No, appeal is pending.
appeal list.
So what is the
What is
status
the
of the
regarding the appeal, my lord, some legal views and other, my lord.
All right, then we'll dispose the matter, directing them to dispose of the appeal within a time.
Lord, that can be done.
Lordship, in appeal, normally they have not asked, have not taken any step as yet. Notice may be issued.
Your
And
prayer is that you had filed an appeal is pending. You
Where?
want to pursue the appeal and also pursue the writ petition. You have to pursue either. Either you go and withdraw the appeal. We'll hear your matter.
We will not participate.
It is up to you. The appeal is pending. That is the statement you made.
But since department has not taken any step.
Therefore, we are
6 to-
directing the department to take steps within a fixed period and we are closing the matter. Pass orders on the appeal within 30 days. Third council for the by the order dated issued by Senior Sub Registrar Kamrup Metro dismissing.
Lordship, keeping the disposition alive.
Can be done. Order of dismissal as an extra rider under the office of the Senior Sub Registrar Kamrup Metro. Stop. Order of dismissal was issued by the Inspector General of Administration, Assam. Stop. Being agreed, the petitioner is preferred an appeal to the Commissioner and Secretary Revenue, Department of Revenue, Government of Assam on 6/2/2026. Which is the appellate authority? Secretary,
Lordship.
Commissioner and Secretary.
Lordship, Commissioner and Secretary. Lord, Principal Secretary, Additional Chief Secretary.
Huh? Appeal
Additional
is before the commissioner and secretary.
Now, Commissioner and Secretary is, that post has been abolished. After that, the Principal Secretary is there. Now, that Additional Chief Secretary is there.
Appeal is pending. Appeal was filed on 6/2/26. So, the last date, standing council review was permitted to obtain instruction. Council for review submits that he has been instructed to seek further time as certain clarification was sought for by the department. Respect of the appeal is pending. So, submitted by the standing council review that the office of the commissioner and secretary revenue government of Assam is not, has been abolished, and therefore appropriate authority is, what is this? Principal secretary,
Additional Chief Secretary,
additional chief secretary,
Revenue.
department of revenue, government of Assam. Stop. Under such circumstances, additional chief secretary, although not specifically arrayed as a party, in the post title directed to call for the records of the appeal filed on 6/2/2026 before by the petitioner before the commissioner and secretary revenue of Assam, and expeditiously consider the phrase making pass a speaking order. Stop. Let this exercise be carried out within a period of 30 days,
60 days.
60 days from the date of receipt of copy of this order.
Chance of hearing may be given.
Needless to say, before the appeal is disposed of, the petitioner will be given an opportunity to dispose.
Return order may be communicated.
You will be appearing before
Available
the authority.
wanted to appear in the hearing. Lord. Obligation.
Yes.
Here you also challenge the search sheet, your lordship. Issued by the respondent employers, your lordship. That is a page your lordship will get it there. Page your lordship will, that page 108, 119. Memorandum of Funds.
Yes.
Lordships may kindly come to page 121, article of salary. Now, essentially, your lordship 3, from there they have made it 7. That the Sage Sri Montu Burman, that is the petitioner, failed to submit his annual immovable property return for the calendar year 2024 by mandatory due date of 31st January. Right? As required under so and so CCS conduct rules 1960, thereby have been stated applicable to every government institute under rules so and so of the Central Civil Service Conduct Rules 1964. That Sage Sri Montu Burman, despite repeated written direction, same your lordship that I have not submitted that. Then 3.
Have you submitted reply?
Yes, Your Lordship, I have
Uh-huh.
submitted reply, but Your Lordship, why I will show you from the annexers annexed to the present petition that this does not hold any good, Your Lordship, so far as this search sheet is concerned. Your Lordship may kindly see, and then Your Lordship may kindly come to
What is the prayer here?
prayer, Your Lordship, for passing of this search sheet.
Charge sheet.
The
Why?
disciplinary proceeding.
Why?
That I will show, Your Lordship. This is a complete abuse of the process, Your Lordship. This is the third time they have proceeded against me. One dishonorable.
All right,
court.
let us issue notice.
Your Lordship. In the meanwhile, Your Lordship, if it is goes, Your Lordship will kindly see not submitting IPR, Your Lordship. I have submitted IPR as per their direction, Your Lordship. That I have annexed, Your Lordship. They have admitted. Once I submitted IPR,
Have you submitted your reply?
yes, I have submitted my reply.
Now, what is the stage of the?
No, that has proceeded not there.
So-
They have no further proceeding. Your Lordship. My
It
reply,
may have been concluded, or they may be contemplating to conclude it.
no, they are not, Your Lordship. Because Your Lordship, this is the third disciplinary proceeding initiated against me, Your Lordship. I am
All right, we'll
under
issue
suspension.
We'll issue notice.
Lordship. Your Lordship may kindly, Your Lordship, see the nature in the manner in which this has been drawn, Your Lordship. And the allegation, it will not come within the ambit of misconduct. Your
We'll have to examine that, Mr. Bond.
Yes, Your Lordship. But prima facie, I can satisfy Your Lordship.
Why should we pass any order in a disciplinary procedure?
No, because Your Lordship, this is an abuse of the process, Your Lordship.
So that prima facie view is not sufficient.
I have the documents, Your Lordship, to place before this honorable court that I have submitted IPR. I have submitted IPR, Your Lordship, as per their direction.
You
As
have,
per the
you have
system.
varied the medical superintendent as a party and some other doctors.
Lordship, yes, Lordship.
Then we'll have to issue notice to the third council. for
My lord,
parties to
my lord.
notice.
My lord, may I submit, my lord? For reply of the application, Sachi, he has submitted the application for granting 15 days time. We have granted time, but before submitting the reply, he approved this one.
We are issuing notice. Mr. S. Botabu, the Secretary of Prime Minister.
My lord, is
He has an
pending
exception on behalf of respondent 1, 2, 3, 4,
all the response, my lord.
including private respondent.
No, Your
Private
Lordship,
is not
Your
private,
Lordship,
it's the officers of the institute.
No, Your
But they are
Lordship.
arrayed as
My
in-
lord, there is an order that any order passed by an officer of the institute, and those officers made included as
we
by
are
name
issuing,
taken.
we are issuing notice on respondents 5, 6, and 7.
Your
We
Lordship,
take steps.
may I submit it? There is no requirement to Your Lordship. I will not press anything against them. Only was this. 1, 2, 3.
1, 2, 3, 4.
Your Lordship may dispense.
Notice on 5, 6, and 7 is not issued as the council for the criminal summons that at this stage notice may not be issued as they may not have any claims against the state respondents. Taking into
Personal.
consideration submission. State notice is not issued on respondent 5, 6, and 7. Since Mr. Doctor represents 1, 2, 3, 4 notices away, extra copy funds to be appealed to 1. Then proceedings are continued against the petitioner. Then no final order will pass without appeal of the court.
Lordship. Deeply obliged.
Take my case.
Will you should notice you words on the point of limitation are maintainable. Sir,
Edward,
Edward, you sorry,
respondent 4.
respondent number 4. Respondent 4.
Yes, sir.
Who's drawing up the proceeding against?
1, 2, and 3. Have grievance against 1, 2, and
Who's for 1, 2, and 3?
the each approval to CGC appeared.
CGC, any CGC? Yes, yes, yes. Respondent 1, 2, and 3.
Last.
Chaudhary, RK Dev Chaudhary, he has done the DA, appears on behalf, appears for respondent 1, 2, and 3, and then as L. Devi, accept notice on behalf of assisting API, accepts notice on behalf of respondent 1. Since the question of limitation, maintainability has been urged by the respondents, the same is left open to be decided at the stage of admission. Respondents may complete their instructions and file necessary evidence. Extra copies be furnished on all the respondent accounts within 1 week.
My lord, this case relates to the, my lord, petitioner was serving as a accountant assistant in the office of the treasury, sub-treasury Dhubri. In persons to the some criminal case, my lord, he was placed under suspension, my lord. Thereafter, he is subject to the writ petition. Thereafter, my lord, the honorable court directed, my lord, to conclude the proceeding and to supply the copy of the inquiry. When I asked for the documents, my lord, they said, my lord, it cannot be given, it is a confidential. To that effect, my lord, I like to draw lordship's operative part of the order, my lord, wherein I have challenged the suspension order. That your lordship will see at page at page 61, my lord, operative part. Where it, my lord, small 2 paragraphs. There is a certain directions given that effect. In the event the petitioner, after being served with a copy of the inquiry report, does not submit a representation against the same within a period set out in reliance on a wiki open to the district commissioner Dhubri to proceed with the matter and considering the inquiry report as well as material coming into record in the inquiry, draw the conclusion and pass the appropriate orders. In that event, the disciplinary authority fails to pass the orders, disciplinary proceeding instituted against the petitioner within 30 days. This date may be noted, my lord. 30 days, honorable court granted, my lord. The representation and the petitioner against the inquiry report and lapse of 15 days from the date of the service report, the petitioner as well as case may be concurrency of suspension shall deal to see and petitioner required to be reinstated in his service against the post that would be determined by the respondents. Thereafter, my lord, I asked for the document, my lord. Immediately they have supplied me copy of the inquiry report, my lord. I asked, my lord, some document that your lordship will see at page 71. Page 71. With due respect, I have the honor to state that the charge committee to me so and so has not been furnished to the statement of allegation which are based on list of documents and witness, if any, by the article of charges has been proposed to be sustained so and so in the assumption. Besides, I found that the inquiry which are furnished to me was emphasizing a written statement of the witnesses, documentary evidence on records. Moreover, a chance was not given to me to cross-examining the question of the, and hence it becomes the most essential to know the list of witness along with the copy of the statement. Therefore, thereafter, again, my lord, I have approached to the authority on 14 May, my lord. Where, my lord, next page 72, where for the necessary order, the reinstatement of the suspension, honorable court. So with reference to this, I have the honor to stipulate a period passing. The time has been elapsed, my lord. Disciplinary authority has already been over by the Gauhati High Court on 13/3/26 passed in so and so. Therefore, I request your honor kindly make necessary order for reinstatement and so and so. Thereafter, my lord, they passed the impine order at page 73, my lord. Lordship will see the first, second, third paragraph, my lord. Third and fourth, my lord. Whereas, Mr. After examining careful examination of written statement of the defense submitted by the so and so, that is the petitioner, SD officer who was appointed as the inquiry officer so and so, has submitted an inquiry report wherein it has been reported the charge frame against the commercial right are found to be clearly established. And whereas the inquiry report was accepted by the disciplinary, copy of the same was forwarded to Kamaleshwar Roy and asked to submit the representation against the inquiry report within 15 days received of the inquiry and prayer petition 17 and submitted that the Kamaleshwar Roy seeking confidential, my lord, departmental proceeding. They are saying, my lord, last paragraph, seeking confidential materials relating to the proceeding instead of representation. Because, my lord, in the absence of two documents and list of witnesses and statement, my lord, I cannot give my representation. Thereafter, my lord, I was being dismissed from the service and I have been asked, my lord, to deposit the amount of 17 lakhs allegedly misappropriated by 6 number of persons whose name has been reflected in charge sheet in a criminal process.
What are you challenging?
I am challenging the MP note.
What is the MP note?
MP note on my lord, which is at page 70,
Dismissal order.
dismissal.
Have you filed an appeal?
No, my lord. Through that effect, my lord, there is a decision of the apex court, my lord. Small, like, if your lordship permit me, I'll read out my lord. Where the writ petition seeks enforcement of any fundamental right, where there is a violation of principle of natural justice, where the order passing the proceeding hold without jurisdiction. That I have taken plea, my lord, in my petition, lordship. Kindly have a look at para 14 and 15 of the 2008 SCC.
What is the judgment?
Judgment, lordship?
Citation?
Citation, my lord.
You are not supposed to read judgment without giving the.
My lord, I thought your lordship is aware. That is my mistake.
There's only learned counsels who are aware. How? Why do you presume
Lordship.
judges to be aware of everything?
Lordship. SCC.
You are supposed to educate us, enlighten
my
us.
lord.
Tell us, what is this?
SCC 1998 volume 8.
98.
98 volume 8. Page 1, my lord, and operative part, lordship will see para 14 and 15.
Party?
Party's name, my lord. Whirlpool Corporation versus Register of Trademarks, Mumbai.
Whirlpool.
Whirlpool. Operative part, lordship will see page 14 and 15. And similarly, my lord, another judgment which has been given, my lord.
All right, heard counsel for the.
And I pray for the interim stay also, my lord. Recovery is against.
Mr. D. Bora, IPS 4.
Response numbers 3, 5, and 6.
3, 5, and 6. Say, votable for respondent 1, 2,
Judgment.
7. The respondent are represented by the order of dismissal.
The recent judgment. Supreme Court, my lord, in 26.
You are agreed by the order at page 73.
My lord, agreed by the page 73.
27, 5, 26, where the petitioner was, you were dismissed.
Yes, my lord, I am dismissed from this
Dismissed from service.
and asked for the recovery also.
Thereto, petitioner has been asked to deposit the misappropriated amount of the government exchequer.
Wherein charge sheet, my lord, there is 6 number of us.
So, we agree. Scope. Since although an appellate forum is there, petitioner submits that this being violative of the rules prescribed as also natural justice.
And jury.
And the disciplinary authority the petition has been filed. They are preferring an appeal. In refer to judgment of Whirlpool Corporation reported in
And another one also.
One, there are 14. And
And
also
the corporation.
J. Prakash Saini, This is MD so and so,
Para 4.
reported in 2026 INSC 305.
The decision judgment, my lord, para 4 and para 8.
You submitted that department. Besides the order being without jurisdiction, department is proceeding to recover the amount from the petitioner by way of death notice issue, returnable 4 weeks. Respondent will obtain required instructions in the matter. Issue notice of the immediate death. Matter will be listed again on 31st of July. The next date fixed. No recovery shall be made from the petitioner. In terms of the review order, it is mentioned.
So that judgment lordship will repeat, my lord. The decision judgment lordship will repeat.
If you want, take it back.
No, 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 sir, I got that, sir. For perusal of your lordship.
My plea. The matter is recovery of risk and hardship allowances. CIP person. There are several similar orders.
Where is that order? Give him a copy also. Why don't you share orders that you're placing before the court? Silent letter order. Issue notice, huh?
There are so many cases, sir.
We are passing orders, similar order.
Therefore, take this item with that item.
The repetition be listed along with the.
May I please mention? Petitioner has a legal error of one Dawlat Brahman also. Dawlat Brahman was working as assistant in the Assam Jamin Vikas Board. It is voluntary retirement. As per their regulation, this is entitled for voluntary retirement pension also. But they are not provided. They maintain the Dawlat Brahman expired also. So that they are legal as claiming the pension entitled by the petitioners. Dawlat Brahman.
So who are the petitioners?
Petitioner number 1 is the wife of Dawlat Brahman. 2 and 3 are Ripar and Sami. I'll have to take instruction.
Third, thousand for party issue notice. All the respondents. All the respondents. Extra copy furnished immediately. Claiming the petitioners are towards the pensionary benefits of late Dawlat Brahman, who was an employee under the Assam government at the time. Tendency of the petition will not be barred for releasing the claims made by the legal heirs of late Dawlat Brahman. Just after the return.
I got this better perhaps pensport.
Pensport.
Package.
Gratuity, non-payment of gratuity.
Gratuity, but they are claiming for non-execution of the package.
That is only the process.
Their allegation.
So the claim is towards the gratuity.
My lord, benefits.
Gratuity is a service issue.
My lord, but they are claiming that
They're only claiming the process has not been initiated.
My lord.
But the process they're not agreed by the process. They're agreed by non-release of the gratuity.
Sorry, written from the service, on 16th August 2020.
We should notice heard, Learned Council to party should this Learned Council, 30 year Learned Council agreed for
1, 2, 3, and 5.
1, 2, 3, and 5. Steps of respondent number 4 by speed post within 1 week. Respondents will complete their instructions and file affidavit.
Date may be fixed, madam.
31st July.
Yes, sir.
As a master employee regular. Subsequently, after his retirement, though he is entitled to receive GIS amount, GPF, and leave salary, but DCRGS, death cum retirement gratuity, and the pension has not reached to him, because he was absent from service, for some days, and death period has not been considered as regular.
You know, I heard council for parties should notice returnable NS. Therefore, Mr. Adhar. Mr. Adhar appears on the behalf of respondents number 1 and 6. And who's for finance? MFA Botagor, respondent number 2 and 5. Mr. Boro,
R. Boro.
R. Boro appears for respondent 3. The respondent will represent. We list after returnable.
Right.
That pertains to compassionate appointment. Text you will find at page number 40. And extra 6 year is the earlier order of this month.
What is your grievance now?
Yes, is that is because the OM of 24 years, whether SLC has considered it or not, there was a direction to consider. Recommendation has been by DLC. Next chart 6, page number 40, earlier direction by this honorable court.
We did not file a contempt.
Yes. Already there is a direction.
There is a direction.
Yes. 2018.
Why another direction is necessary now?
18. 5
Now, whether SLC is considered or not.
There is a direction in 2018.
No, how can you?
Huh?
Isn't when done.
This writ petition is filed by the petitioner. Seeking compliance of the direction. Seeking a direction to the respondents to consider. Seeking a direction that, being agreed that the directions contained in the order dated 5/4/2018. WPC 7949 of 2016 has not been. By order dated 5/4/2018, passing window, the following direction was issued, page 41, extent. It submitted that respondent number 5. Respondent 5,
Or 5
the
is
earlier petition.
the fifth secretary.
District level committee.
Huh?
LC.
ELC. Also the respondent 5 did not carry out the directions, so no contempt petition was filed.
LC has.
Since there is already a direction issue, no further direction is called for. Nevertheless, the petition is disposed of, directing the respondents to carry out this order within 60 days from date of receipt of a certificate copy. Disposed. And it's
Already not considered.
It's not already considered. Hormone appears for state,
Yes.
Moses Sharma for
Department.
health department. Blind.
In this case, the petitioner is grieved by my lord the repeated suspension that is at case 83 lawsuit. Repeated suspension lawsuit. Fact is lawsuit in 2022. He was suspended in connection with my lord criminal case. He was my lord a judicial custody lawsuit. Hereafter, after 2 years, my lord, he was reinstated lawsuit. My lord, disciplinary proceeding was initiated. My lord, that disciplinary proceeding was not completed lawsuit. Being aggrieved, my lord, the petitioner approached this honorable court lawsuit. This honorable court directed to my lord complete the inquiry.
Will issue notice today?
My lord, suspension, my lord, repeated suspension, I have an interim trial lawsuit.
For what?
Because already, my lord, the suspension order is not, my lord, this is a repeat second
You
suspension.
want a suspension of the suspension order?
Lordship, my lord, earlier suspend. Very kept in abeyance, lordship, because earlier I was suspended, my lord, again reinstated after 2 years, my lord. It was my lord.
Heard. Counsel. The number 4 weeks, Mr. Magdai.
I am for 1, 2, 4 and 5.
Appears for respondent 1, 2,
4 and 5.
4 and 5. And Roman appears for respondent 3. Again, 8.
Okay, he is by name made party law 6 and 7.
Therefore, notices on respondent 1, 2, 3, 4 and 5 stand clear. However, extra copies furnished. And 8 also. Who's appearing for 8? Personal department. Hormone 4. Hormone will appear for 3
And 8.
and 8. Mr. Upadhyay for
1, 2, 4 and 5.
1, 2, 4 and 5. And therefore, steps of respondent 6 and 7 by speed post. Issue notice on the individual. 30%.
My lord, after getting, my lord, receiving notice from this honorable court in contempt case lawsuit, my lord, the authority, the respondent number 2, my lord, in that case, my lord, the respondent number 2 was a party. Contempt case, my lord. Only after receiving the notice, my lord, this contempt, suspension order was passed lawsuit.
What is
This
the
is absolutely what.
stage of the contempt petition?
Yes, contempt petition, my lord. It was filed. Yes, it was filed, my lord, because my lord, this, my lord,
No, is it pending or disposed?
that is pending lawsuit. My lord, that is why I am praying for my lord interim my lord, order, my lord, because my lord, this was my
It's a
lord
suspension order. It's not a punishment.
on the
as
grounds
such.
of my lord. This is on the grounds of my lord.
We'll
finding
examine
contempt
that on
case
the
law.
first day. How do we know that your contentions are?
My lord, materials before you lordship the contempt notice of the contempt
No,
case, my lord,
we are issuing
lordship's order, my lord, the
We are
request
issuing notice on the interim prayer.
like well, a short date, maybe.
Short date. On the 24th of July.
Lordship.
All right.
I'm driver under full transport organization. Transport. I have been superannuated on 31/3/2025. My service was supposed to was issued by the for unauthorized absence, but no action was taken. Now I have approached because I have been deprived of pensionary benefits and
So we kindly have a look page 12, my lord. Nature of engagement of the petitioner, my lord. Page 12, annexer 1, my lord.
Oh.
The second paragraph, my lord. The appointment is purely temporary and may be terminated at any time without assigning any reason. The petitioner did not annex any regulation order of his service. Lordship, I will get instruction, lordship.
Right, comfortable parties. Appointed as the driver. Under the transport department and for superannuation is retirement benefits and government benefits. MSMD Bora, the standing counsel for the department. Referring to annexure 1 of the petition, submits that the petitioner was engaged as a temporary driver and therefore there is no material to show that the petitioner was subsequently deprived entitling him for pensionary benefits. He, however, submits that she would like to complete her instructions in this manner. Matter being listed on 24th of July.
Yep.
Although notices are not issued, extra copies will be furnished within a period of 3 working weeks.
Madam, my lord, area salary from June 2020.
MS Sharma appears for respondent 4
I am for 123.
and the Bora for 1. Pendency of the writ petition shall not be a bar. Redress the claims of the writ petitioner regarding area salary.
Obliged. Consider picture 24.
24. Go back.
Obliged.
Please, Your Lordship, in this matter, Your Lordship, there was a preliminary inquiry which was being conducted by the Inspector General of Prisons, Your Lordship, upon an allegation of harassment committed by the petitioner on a female warder. There was a disciplinary proceeding initiated, Your Lordship, on 3/6/2025, wherein a show cause notice was issued to the petitioner. And the petitioner thereafter was suspended on 30/8/2025, Annexure B, Your Lordship. Your Lordship, the petitioner has made a representation on 26/11/2025, Your Lordship, for reinstatement, Your Lordship. But however, Your Lordship, till date, the petitioner has not yet been reinstated, Your Lordship.
Where is the order of suspension?
Yes, Your Lordship. If Your Lordship has a perusal at page number 32, Your Lordship, Annexure B, Your Lordship.
Okay.
Yes, Your Lordship.
Please continue. So,
And the inquiry has also been completed on 17/9/2025.
What you have submitted your reply.
Yes, Your Lordship. I had submitted my reply, Your Lordship. If Your Lordship has a perusal.
Will issue notice for the
Yes, Your Lordship.
third council party. The CP is over. State of the appeal to the apple responding 1, 2, and 3.
Lordship,
See the respondent the representative notices over the extra copy.
Your Lordship, I pray for it, Your Lordship. The prolonged suspension. Your Lordship.
31st July. We next the matter on 31st.
Awesome. Much obliged. Your Lordship.
The petitioner was told that he was working as an assistant training officer, my lord. A show cause notice was issued, inquiry was conducted, and the order of dismissal of penalty was issued to the petitioner. As per Rule 15, my lord, appeal lies to the my lord. Accordingly, appeal was filed, my lord, on August 2025, my lord. Appeal has not yet been disposed of, my lord. Without going into the merit of the case, my lord, and the procedural irregularities they are there in the inquiry report, my lord. No opportunity of cross-examination was given. So appeal has not yet been disposed of. At this stage, my lord, without going into the merit of the case, lordship, I pray for a disposal of the appeal by the authority, my lord, within stipulated freedom.
Third, Mr. Right. All right. Petitioner was serving as a research assistant in the office of the deputy. When he was promoted to the post of assistant planning officer. Service under the office of the deputy commissioner Maguli, Department of Proceedings initiated. Charges were framed upon completion of the inquiry. disciplinary authority by order dated 6/25 imposed a major penalty of dismissal from service. Stop being agreed. Petitioner has preferred an appeal under the Discipline and Appeal Rules 1964. Stop. However, when was the appeal filed?
Annexure 9, page 43, 29/8/2025.
29/8/2025. However, date. As per the information available to the petitioner, the appeal has not been disposed of. There are learned senior counsel at this stage submits that in limited prayer is that the direction to the appellate authority. Who is the appellate authority?
Appellate office, the governor, by appeal was filed through the, my lord, respondent number 4, my lord, secretary to the,
Respondent 4, the secretary to the governor of Assam, Rajbhavan. Director.
who and 4, my lord. Who
The
is processed,
secretary
my
of the
lord?
department. The appeal was routed through the office of the secretary.
My lord.
Directed to dispose of the appeal as expeditiously. Mr. Bora, hearing for the respondent, submits that at this stage he doesn't have any instructions as to whether the appeal has been disposed of. Considering submissions made, the petition stands closed, directing the respondent authorities, more particularly respondent number 2 and 4, expeditiously consider the appeal preferred by the respondent, by the petitioner, and pass appropriate orders thereon in a period of 60 days from the date of receipt of a certain date copy of this order. Needless to say, in such order that may have been passed, copies thereof will be served on the petition. If not already disposed in a period of 60 days.
May I please?
Yes.
This case noted second round litigation noted. The petitioner was initially appointed as a master worker, appointed annexure D, page number 20. Babul Hadoja, he was initially appointed as 1/6/1994, and thereafter he was appointed as a temporary government employee, that is annexure C, page number 18, 23rd December 2009. He was appointed as a temporary government employee. Subsequent, it says he died in the meantime. After his death, he filed representation before the authority for seeking pensionary benefit, but not granting pensionary benefit. He has filed earlier one litigation before the Honorable High Court. Accordingly, High Court passed an order dated 24/6/2024, annexure E, page number 24. But Honorable High Court passed the order only due to consideration of Upendra's husband, because at that time petitioner is unable to prove joining letter of her husband. That is why Honorable Court directed to release the pensionary benefit in pursuance of the Upendra's husband. May I please to read the relevant paragraph law. In the event, page number 26. That in the event petitioner is found entitled to any amount within the benefit of as extended by this court, in the case of Upendra Supra, the same shall be released to the petitioner within 2 months from the date of receipt of certified copy of this order, along with the said representation now required to be filled in the matter by the petitioner here. After receiving such certified copy, Lordship, the petitioner has approached before the authority by filing a detached representation before the authority, that is the annexure F, page number 27. And after receiving the representation, authority has only passed one letter from one authority to another authority, and then matter has been been pending before the authority and not granting the pensionary benefit. Now, Lordship, Your Lordship, the petitioner has again filed one another representation wherein annexer page number 38. Page number 38. Page number 30. Annexer 8. Page number 38.
So what is your prayer here?
My prayer is that Lordship might kindly will go through my representation, page number 38. My prayer is that the claiming pensionary benefit of my deceased husband in addition to para number 22 of the state of Assam Upendra Act. Now, the Upendra is already gone, Lordship, set aside by the Honorable Supreme Court. So I am entitled to get pensionary benefit of my deceased husband. Wherein the similar situated cases, the Honorable High Court has dismissed one writ petition. Accordingly, the state agreed the state writ petition writ appeal has been filed and writ appeal has also been set aside by the Honorable Supreme Court. Your Lordship, may I draw attention the writ
You
appeal?
should notice here.
Lordship, Sukhendu Bhattacharya is applicable because date of engagement is confined to only 1/4/1993, but his date of engagement is 9/6/1994.
No,
Lordship,
absolutely missumption she made before this Honorable Court. Lordship, may I draw attention?
Paragraph 79.
So, paragraph 100.
Lordship, I am for 1, 3, and 5, my lord.
1, 5, getting to respondent 4 and what are the Still after the
Of letter.
In this matter, my lord, the petitioner then common party help by my lord. He was working since 2009, my lord. That happened January 2023. The worker has nominated accordingly he submitted a representation before the CDPO, the concerned CDPO. My lord, but that has not been responded. Thereafter, my lord, a so-called notice has been issued upon the petitioner, my lord, for her absence on 27th October 2023. Now, thereafter, the petitioner replied. Nothing has been done. Thereafter, my lord, again another so-called notice has been issued for her absence on 3rd of November 2020. Now, that was also replied, my lord, but nothing has been done. But her honorarium has not been given, my lord, since, my lord, 2022. That is, my lord, 1 month of 2022. Thereafter, in 2023, 4 months honorarium has been paid. But thereafter, nothing has been paid to her, my lord. Accordingly, the petitioner has submitted a representation.
get instructions, Mr.
My lord, suppose not itself a allegation of the unauthorized absence. If she is absent, my lord, there is no question of the payment.
Where is the show cause?
There are two show cause, my lord. One show cause issued, my lord. That is case number 29, my lord. Second show cause.
First one is at page 27.
What reply did you give?
My lord, he has replied, my lord, reply is at page 30, my lord. But the contents of the reply is, my lord, on her level base, my lord. So, not very clear, my lord, what she
Both
wants
the
to
show
say.
causes are for the same period or different periods.
Different period.
Period is
Both are
different
different
also,
for
my lord.
different period.
The allegation also different, my lord. First one, my lord, she left the meeting, my lord, during the continuation of the meeting, and second one is regarding the unauthorized absence. Second, suppose page number 36. Both are separate, and she has made reply in the both suppose.
But after reply has been submitted, my lord, nothing has been done by the concerned authority, my lord. Only salary has not been given, my lord. That is, I can't say that because of that the salary has not been paid, my lord. My lord, the honorarium has not been paid since 22, my lord. And subsequently, my lord, I like to draw attention to page number, my lord, 46, my lord. Here another representation, my lord. Stating entire thing, my lord, she has submitted a representation for the district commissioner, my lord. My lord, in that representation, she also stated another thing, my lord. She has been harassing by
Now, pursuant to the notices which were issued, the proceeding was initiated.
There, my lord, I have no instruction on that.
Get your instructions.
My lord, that instruction.
Heard counsel for parties. Mr. Soikiel and State Council representing the respondent will obtain required instructions. And this is the not issue, the extra copy will be furnished within a period of 1 week. Give copies, extra copy. Matter be listed again on 31st of July.
my lord notice issued, my lord. Only for instruction, my
Yeah.
lord, it's a long time, my lord.
Then 24th.
My lord, notice may be issued, my lord, according
Why?
to
Why?
the,
What is status?
otherwise, my lord, can the short date may be given before petition, my lord.
Before vacation, not possible.
My lord, otherwise, it's a long time, my lord.
Otherwise,
Yes, they are one body helper, my lord.
my lord, if so
Not an
notice has
officer,
been
my lord.
replied, my lord, after department has not
All
initiated
right,
proceeding.
My lord, we have
now
three,
you
my
can-
lord.
26th of June. Get your instructions.
Right.
26th. Provided you serve copies within 2 days.
During the good day, my lord.
Must
My lord, right now I am having
serve.
apply to the.
Next, there is, my lord, as per the statute, the review board has issued a directive. And as per the said directive, my lord, first of all, my lord, all the transfers of the members of the Railway Protection Force is to be completed on or before 31st March. Secondly, there is a provision for working couple. Working couple.
Working couple.
For the husband and wife should be posted in the same place. Now, my lord, what happened, my lord, in violation of those, all those guidelines, my lord, they have issued the improved transfer.
So which is the impugned order?
Improved order is at page Miller 32.
32. Yes. You are at
My
serial number
serial
9.
number is at serial number 9.
Serial 9.
9.
So you transferred from headquarters to Katia.
Katia.
So what is your grievance?
Grievance first grievance is that, my lord, they have issued the transfer order on 11/6/2026. They must complete it within a period on or before 31st March. Secondly, there is a provision for couple transfer, which they earlier considered, which I have annexed, my lord. Annexure 3 case 36.
Your spouse is also working where?
Working.
Here.
Here.
Mr. Chaudhary,
So far as spouse is concerned, I do not.
he doesn't want to go alone. He wants his spouse to accompany.
That is the pleaded case.
Ah.
His pleaded case is, his child is midterm.
Midterm, that is also.
Child is in midterm. It is not his pleaded case regarding
That is why, my lord,
spouse. So worship, in any case, worship, I do agree it would be a midterm. Worship will allow me to take the instructions by next week. Till then,
Heard counsel for parties.
otherwise, this is only a guideline. Worship does not have the force of a statute.
Respondents obtain instructions with regard to the transfer order dated 11/6/2026 as to why the procedure laid down in the guidelines have not been followed so far as the petitioner is concerned. Based on
Wednesday, worship? Next,
24th, next Wednesday,
yes, ma'am.
till then I may be protected.
the photo notices are not issued. Extra copies will be furnished within the course of the day. Till the next date of listing, which is 24/6. Status will be maintained in respect of the transfer order, which should be the petition. In respect of the place of You say the transfer order, the transfer order, if it's going through, so far as the petitioner is concerned, shall not be.
Yeah.
Provided lordship, he has not been released as on date.
Subject to the petitioner not being released as on date. Are you released?
My lord, yesterday I was in the hospital, my lord. I mean, I do not know my lord, whether I'm spare or not.
Yes.
But since it is a prima facie, it appears my lord, they have violated, so it is. But the
Yes.
next one is also my lord, with regard to the constables.
Ah.
Here also they have issued same allegation, my lord.
Same order, 24th.
Here, lordship, there is a difference. Here, they are transferred on promotion. I'll just point out lordship,
One promotion or you don't, you want to
My
follow
lord,
your promotion?
we have already submitted our unwillingness. Even then we are promoted. And the main thing, my lord, whatever it is, my lord, they have obtained our choices, everything. But that is not considered. And we are posted out of our choices.
Can you get instructions by next Wednesday?
yes,
Same order.
Deeply on.
May please your lordship.
Yeah.
The matter is relating to two issues are involved in this case. One is the non-consideration of the non-granting the pay scale of as per the, that is AICT or the UGC pay scale. And number two, appointment of the director in Northeastern Regional Institute of Water Management Task Force. This is the two, that is the issue. I am presently working as the in-charge director of Northeastern Regional Institute of Water Management Task Force. Lordship may see, I have been initially appointed, Lordship, paragraph 3, page 17.
So you are agreed by which order?
Agreed by appointment of the director because 2012, that is the our institution
You
has
are
been
agreed by the order at page 85.
85 lordship. And moreover, lordship, because due to non-sanction of the, that is the
We
UGC.
examine the matter. We should notice today, let them complete their instructions.
Yes,
fine. And we say that this order shall be subject to the outcome of the writ petition. Because this person will have you arranged this person?
A
He's
person
made
has not joined it today.
he is made party.
He is made party,
He's
so
made
we have to issue notice to
Yes.
him also.
At least interim protection should be granted.
What interim protection?
Because,
That will be subject to outcome. lordship.
oh,
Administrative. Thus, council.
And for lordship 1, 2, 3, 4, 5, and 8.
Assisted by Mr. Dana, yeah, it is the 1, 2,
1, 2, 3, 4, 5, and
One.
8.
1, 2, 3, 4, 5, and 8. And who
Six,
appears for 4?
4 I agree.
4 you appear.
Yes, lordship.
3 also.
1, 2, 3, 4, 5,
1, 2, 3, 4, 5,
and 8, lordship.
and 8.
6, 7 will have to.
6.
UGC, I think Mr. Samu appears.
UGC, Standing Council UGC, served copies.
And AICT,
Standing Council UGC and AICT, is there a Standing Council?
I'm
Or otherwise you can appear on AICT also. Mr.
lordship, I'm told Mr. Samu also appears. Yes.
Standing Council for respondent number 6 and 7. Served copies. Therefore, notices the way with respect to respondent 1 to 8. Respondent 9 the served copies by way of speed post within 1 week from the petitioner is agreed by the non-consideration of his candidature for the post of director of Northeastern Regional Institute of Water and Land Management Test Board. and more particularly the order dated 4/6/2026 issued by the Department, Ministry of Jal Shakti, appointing the respondent number nine as a director in place of the petitioner, who is presently serving as in charge director.
In charge director.
Let the respondents complete their instructions and file necessary evidence. The issued order dated 4/6/2026 appointing respondent 9 as the director in the date subject to the outcome of the research. Matter be listed after the returnable date.
All right.
Kindly draw for time being. Time being.
No time being. No time being, we are issuing notice.
Who is coming home? Coming home.
We are issuing notice here. What else?
My lord, our case is due 3 days, my lord.
Huh?
Within a short time, my lord. There is every possibility that it now will be dismissed.
Then what is, can there be an order that he shall not be dismissed ever without following the procedure of law?
One case is that there is a simultaneous criminal proceeding.
Hmm.
That case, my lord, there is a judgment.
No, what is the stage of the criminal proceedings?
Criminal charge sheet has been filed to our end.
What is the charge sheet?
Charge sheet have not received yet. my lord.
You get the charge sheet and tell us that the grounds are one and the same and you will be prejudiced.
Yes, my lord, and in time, my lord.
No. Without knowing what are the charges? What are the charges? You say the same charges.
My lord, kindly, basically, my lord, yes, kindly see the FIR and the, my lord.
FIR is nothing. You have to see, you show us the,
It's a trap case, my lord.
you show us the charge sheet file. Where is the charge sheet? Then,
We do not have that case, my lord.
then how do you presume that the same charges and these are one and the same?
What that, my lord, sometime, my lord.
You get your instructions next week.
In time, my lord. Worship order, my lord, is passed.
No, what worship order?
My lord, if they.
There is a department proceeding initiated.
Yes, my lord.
You have submitted your reply.
Yes.
Inquiry officer, presenting officer appointed.
Everything done, my lord.
Inquiry started.
Inquiry started.
What is the stage of the inquiry?
My lord, inquiry report has been given, my lord. Saying that charges have been. Then that is our case, my lord.
What is your case?
My lord, if there is a simultaneous criminal proceeding, my lord.
That argument would have made at the initiation of the proceeding. Now the proceedings are complete. The hardship prejudice that you said you face by disclosing your defense is already disclosed in the inquiry, before the inquiry. Now the department will either accept or reject the inquiry report. That is the stage.
My lord. This inquiry report is taken into consideration.
Has to take into consideration.
And on the basis of the inquiry report, my lord, any action is taken, my lord.
Then you have a remedy, file appeal, come to the court.
My lord, my humble, my this may be at this stage, my lord, for some time, my lord, sitting, my lord.
No, it can't be done like that. Why? Why? Paul Anthony doesn't say so.
Voluntary, my lord.
You show us where the inquiry report is not to be continued.
My lord, paragraph 22, my lord. May I read, my lord?
Read.
The conclusion which are deducible from various decisions of this honorable court referred to above are: number one, departmental proceeding and proceeding in a criminal case can proceed simultaneously as there is no legal bar. They are being conducted simultaneously or separately. Two, if the departmental proceeding and criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employee is of grave nature, which involves complicated question of law and fact, it would be desirable to stay the departmental proceeding till the conclusion of the criminal case.
What are the charges in the criminal case?
Same charge will be there, my lord. Because the
What
debt,
definitely same charge?
the debt case, my lord.
We don't know, you know, you charge sheet is filed against you. You are not given a copy of the charge sheet.
No, my lord, charge sheet, my lord, two of our information charge sheet is filed. We are not sure, my lord. whether
You're
charge-
not sure and come. Be sure and come. The inquiry is complete. Inquiry proceeding, inquiry report is submitted. Now it is only a question of taking a decision on that.
So far, last communication is given to the petitioner, my lord. If you contemplation good measure.
Where is the last communication?
And another thing is that, my lord, in this case, my lord, initially this court asked an order to reinstate her in service, my lord. They did not reinstate, instead of reinstating, filed contempt petition, my lord. From receipt of notice of contempt petition, my lord, they prepared appeal. Appeal was dismissed, my lord. Permitting 6 weeks more time to reinstate her in service, my lord. Now they are, my lord, for completion of 6 days, my lord. They are-
Yes, Mr. Chaudhary.
I don't know, also can we see how they are disobeying the order of the Senate court, my lord? 2 times the Senate court directed to reinstate. And now,
Then
my
you-
lord, on
then
getting the
you-
last one,
It is an order, it is a case of disobedience, you file contempt.
no, I'm just bringing, because now they have passed an order, my lord. They're saying that it means, my lord, they have to predetermine, my lord, they have to, my lord, impose the measure of penalty, my lord. That is how it appears from the letter, my lord.
But where is the bar?
No, I'm not saying, bar is by the criminal case, my lord, on the same issue, same witnesses, same,
That bar is prevent you from facing any prejudice in the trial, isn't it? So if the proceedings are subject to correction, if the proceedings are allowed to continue, you may be required to disclose your defense before the inquiry officer. Same defense you will be required to take before the
The criminal-
criminal proceeding. Here is the case where the inquiry has been completed.
I am so saying that how they have come to that conclusion, I am only on that point.
So then,
And your logic can is the order.
as on date, the inquiry report has been submitted.
Yeah.
And the disciplinary authority need to take a decision. May agree, may not agree, partially disagree, so many options are there. Assuming the disciplinary authority agrees and imposes the punishment, there is a provision for appeal also. But this prejudice aspect at this stage, whatever defense was required to be disclosed has already been disclosed.
Only one the Supreme Court decision, my lord, kind is subject to your lordship's. That was it. So one day that my continuation, my, as far as possible, my lord, both should not go together. One,
No, it is to the contrary, that there is no law that prohibits
I'm
continuation
not saying that
simultaneously.
Supreme Court did not completely, there is no law, but it is there what the Supreme Court says, my lord, also already saying, my lord, that if the
That is-
department proceeding and the criminal proceeding are based on the identical and similar set of.
Exactly. So that's for the first question put to Mr. Chaudhary Junior is, what are the charges against the criminal trial that he doesn't know?
No, charge what is my simply my it is a theft case, my.
No, but for a
Both in both the case, FIR same, shock was also same.
but charge sheet has to be filed.
That we do not know whether file or not, my folks.
That information we wanted him to find out and tell us that these are the charges, identical.
Then let it come to tomorrow, day after tomorrow, no need.
Day after tomorrow
Day after, we'll see, madam,
or on Monday.
or Monday, then Monday. The meantime,
In the meantime,
my lord, your lordship knows how the executive works, my lord. On the, my lord, one order say that he post her somewhere else. Second order do the same thing.
we will discuss this matter on Monday. This may be council. Price report is together. Charge sheet, respect of connected to, what is the case number?
Criminal case number, oh,
Yes,
yes, SCB PS case number 1524.
ACBPS case number 15. of
They put a
2024,
second line of synopsis.
under section 120B of IPC read with section 7 small e of the Prevention of Corruption Act. Matter is pending. Report special judge summit. Also submitted that the inquiry officer has proceeded with the inquiry and the inquiry report has been submitted to the authority, has issued a notice. Where is the second notice? Yes. The last one.
Page 59, annex 10.
Has issued a notice dated 3/6/2006 enclosing the inquiry report. Calling upon her to submit a representation in the inquiry report. Submitted. Reply.
No.
Reply has not been submitted. Better. Release this matter again on Monday.
No correction.
But coercive action, unless the action is undertaken, then
The worship knows how the work. Particularly.
it is submitted that the disciplinary authority has not passed any order at all. That be so, then not be proper to restrain them from passing an order. Right? Because they are going as per the rules. But if you want time to file your reply, we can give you that.
Yes, madam.
Petitioner permitted time till what? Tuesday, Wednesday?
1 week.
1 week means
Today is Wednesday.
today is Wednesday already. Petitioner is permitted time till 24th of June to submit her reply. Matter be listed on 25th of June. Till the next date fixed. The respondent authority will not pass the adverse order against the writ petitioner till 24th without receiving copy of her reply in reference to the in pursuance to the notice dated 3/6/20. It's on 25th of June. Although notices are not issued, extra copy will be furnished to Mr. Sarma. And he may obtain required instructions on the matter.
This is very well excellent. And very well the Prodi who that was serving and he after days pillar his wife number 5 success. And there is a compromise as per that order was granted. And after that we kindly similar page 27 and accept 3. Some that CRG amount has come and ask it should be come to are also exceed 300 as the 2 hours. And with the AG will be granted all the money to the resident of time. That is the difference. So, go
Council for party should number 1. 6. Mr. B. Sharma for respondent number 2. And for finance, anyone for finance? And then see what I go for respondent number 4. And therefore notices on respect of respondent 1, 2, 3, 4 and 6 stands waived. Our extra copy furnished within a period of 1 week. Stay steps on respondent filed by bit both. After the examination. Names of all counsel, including respondent counsel, reflected in the cause list by the registry.
My lord, the petitioner is presently, my lord, serving as the reader, the Regional Dental College, my lord, Gauhati. Now, what has happened, my lord, due to the inaction or wrong action of the respondents, my lord, now the petitioner is facing a threatened action from, my lord, being denied of consideration for the promotion, the next promotional post of lecturer. My lord, what has happened? Sorry, my lord, the post of professor. My lord. Now, one date, my lord, is relevant. If your lordship, my lord, takes note of this date, that is, my lord, 15/6/2017. Now, while my lord serving as, my lord, demonstrator, which was subsequently redesignated, my lord, as tutor, he took, my lord, study leave, my lord, from the government, and thereafter, he pursued, my lord, his master's, MDS. And in, my lord, May 2017, my lord, he completed. Thereafter, his name was duly, my lord, enrolled in the Assam State Dental Council, my lord. If your lordship comes to page 40, Annexure 5, this is the registration, my lord, under the dentist registration certificate. Your lordship will see the name, Deveswar Das, page 40. Qualification, my lord, Master of Dental Surgery. And your lordship will see passing year, May 2017. Thereafter, my lord, after acquisition of that degree and completion of the, my lord, study leave, he joined, my lord, on 15/6/2017. The next page, my lord. This, my lord, this is relevant. And the original application joining report is at page 42. Your lordship will see it's addressed to the commissioner and secretary through the principal. The date, my lord, of my lord joining is 15/6/2017, and this has been forwarded, my lord, to the DME on the next date, 16, my lord, 6/2017. Thereafter, after his joining on 15/6, he continued, my lord. Now, in terms of the DCI rules, my lord, Dental Council of India rules 2017, once, my lord, acquisition of the master's degree, he completes, my lord, 4 years. Then he becomes eligible, my lord, to be promoted to the post of, my lord, reader.
He joined as a
Tutor, my lord. He was
tutor,
yes,
demonstrator.
demonstrator. And during
Now, what is the meaning? What is the meaning here? I want to join in my previous post.
My lord, page, my lord,
Page 42 or 41.
41. My lord, in fact, he took study leave, my lord, while, my lord, serving as a tutor, demonstrator. So thereafter, after, my lord, the permission from the government, he pursued the MDS. Thereafter, the rejoining, my lord, the joining date is 15/6.
So he's rejoining.
Rejoin.
This is a letter for rejoining.
Rejoining, my lord, in the post of tutor. Now, my lord, what I'm trying to say, pursuant to acquisition of the MDS, the counting, my lord, of the 4 years will start from 15/6. Once he completes 4 years, pursuant to his MDS, he becomes eligible for the post of reader, my lord, in terms of the DCI rules.
This 4 years will also include his study leave.
No, 4 years will be counted from 15/6 because pursuant to acquisition, my lord. Pursuant to acquisition of the MDS. So 15/6 is the counting date, my lord. Now, immediately thereafter, on 15/6/21 or before that, on completion of the 4 years, my lord, he submitted an application that your lordship will find at page 57, addressed to the DME, my lord, saying that now I have become eligible for the reader, post of reader. So please promote me, my lord. Now, this application was, my lord, forwarded by the principal, my lord, to the DME, page 59, my lord, on 28/6/21. Thereafter, in between, my lord, nothing was done. Eventually, in 22, my lord, page 64. This is, my lord, the letter of the DME, whereby, my lord, his application was forwarded to the Commissioner and Secretary of the Government, saying that in terms of the, my lord, DCI rules 2017, he is eligible, my lord, for promotion, my lord, to the, my lord, reader. Thereafter, your lordship will see only
my lord, in 2024, page 70, my lord, this particular notification was issued promoting him to the post of reader. And this is, my lord, the bone of contention. Now, this particular letter has come in my way for promotion to the next, my lord, promotional post of, my lord, professor.
Why?
Because, my lord, in June 21, the post was lying vacant of, my lord, reader. I immediately applied. I made my claim against that post. My application was also
15 June 2017.
21.
21.
21.
After
4 years.
4 years.
4 years. 21. My application, which I have drawn your lordship's attention, that is on, my lord, page 41. Sorry, my lord. That is on page 57. On or before, my lord, 15 June, I had submitted this application. That is on 11 June, saying that the post of reader is lying vacant. I have been rendered eligible, so consider my case for promotion. So eventually, my lord, the application was forwarded in 22 and the promotion order was passed in 24. So from 21, my lord, 15 June till 24, my lord, this 3 years, my lord, service, my lord, teaching experience has been, my lord, left out. Now, my lord, for the promotional post of, my lord, professor, I required, my lord, 5 years, my lord. Now, if, my lord, this order was passed in 15 June 21, by 15 June 26, I would have acquired the eligibility of 5 years, my lord. Now, due to this order, my lord, now I am deprived of from being considered for promotion to the, my lord, post of, my lord, professor.
Now, this reader,
My lord.
he became reader in 24.
24,
24.
my lord, the post was vacant in, my lord, 21.
When did you raise this claim?
In, my lord, when I acquired my teaching experience for 4 years in 15/6/21, my lord. That is the application at page 57.
Was any other person
No.
similar to you considered?
No, that post was lying vacant. They could have considered. They did not consider it. Application was immediately, my lord, forwarded to the competent authorities. They did not do. They did nothing, my lord. In 24, they have promoted me. Now, these 3 years of experience, my lord, I am deprived of that teaching experience of 3 years. Because by this time, they are, my lord, initiating the promotional, my lord, exercise.
No, but they, after in 24, you were promoted.
Man.
When you should have been promoted in 21, according to you.
Yes.
You accepted the promotion. There was no challenge specifically made that give me the retrospective benefit or anything. There's no claim also.
No, in fact, in the meantime, I filed one writ petition. The Honorable Court has made it clear that the DPC being the competent authority, they will consider this aspect of the
No, but
matter.
they cannot consider unless the process starts for giving you promotion with effect from 21.
My lord, my submission is, my lord, I made the claim in 21. Post was lying vacant. It is not a case, my lord, there was no post. I was eligible. 15 June 21, I was eligible. That was not considered.
All right, that will be examined.
Yes, my lord. In fact, what has happened, Lordship will kindly see, my lord, by this time, my lord, EME has initiated the promotional process, my lord, and asked all the principals, my lord, to send, my lord, the records, including ACR. Your Lordship will kindly come to page 989. This is the 27th May, my lord, 26 order addressed to all the principals.
Right.
So, my lord, my humble submission is, my documents may be considered, they may forwarded, my lord.
Have you attained the eligibility?
I have attained it. On 15 June, my lord, 26, I have acquired the teaching experience of 5 years for the post of, my lord, professor.
And how many vacancies are there for the post of professor?
That instruction I don't have, my lord.
What
But
is the-
I come within the
what
zone
is
of
the-
consideration.
No, that will be dependent on the rules. How many numbers are to be sent?
My lord, it is always, my lord, 1:4, my lord. Always.
1:4.
Yes.
So how many posts are there?
That instruction I don't have,
And
my
how
lord.
many persons above you?
My lord, as per the gradation list, my lord, if your lordship comes to the gradation list, I have annexed the gradation list. Only one person above me.
Your papers have not been sent.
No, not my lord.
Why, Mr. Govind? Not eligible.
First of all, Lordship will see page 49 for the moment. It has not been placed before his honorable court.
page 49. After acquiring the PG degree, my lord, on 2010 to 2020, the petitioner was redesignated as lecturer. Page 49, Lordship. Lordship will be serial number 3.
Yes.
Petitioner's name, my lord.
Yes.
He has acquired in May 2017 the postgraduate degree, my lord. Now, by this letter, that is a 2010-2020, along with others, my lord, he has been redesignated as a lecturer from the post of tutor. The Lordship will see, may I read the first part. With reference to the letter on the subject cited above, I have the honor to enclose here with the proposal submitted by the principal in charge, Regional Dental College, Gauhati, by number so and so, regarding designation of tutor as lecturer of the Regional Dental College, Gauhati. The list of tutors requested for redesignation as lecturer at Regional Dental Gauhati are shown below. So here, my lord, respondent or petitioner's name is there as serial number 3. So, my lord, from this 4 years will be counted. 4 years service in the post of lecturer. So in 2024, he has been promoted to the post of reader. Now, my lord, from the post of reader, my lord, another 5 years experience is required to be eligible for consideration.
He was promoted in which year?
Lordship will see, my lord, it is in page 70.
I'll clarify at my learned friend.
70.
Yes.
No.
Page 70, my lord. He has been promoted to the post of reader.
Reader.
It is on, my lord, date is 19/9/2020.
Then what is the criteria for professor?
Professor 5 years
5 years.
as reader.
5 years.
5 years as reader.
Reader. So it will
5
be
years
by
as reader.
2029.
Reader.
Then you were promoted on 24 only.
Yes.
That is why I'm saying, my lord, Lordship will kindly appreciate. My lord, this particular, my lord, promotion as lecturer, I have annexed. It's not that I have not placed before this honorable court. Page 55, I have annexed.
No, where are the rules? Are they available?
Yes,
here?
available, my lord.
Yes,
Available
sure.
on record.
Sure.
If your lordship comes to page 80, the front page, my lord, is not. The rules, my lord.
Eligibility. Okay.
Yes. No, guys, front page to the other.
Professor.
The regulations are known as, my lord, Dental Council of India, Master of Dental Surgery Course Regulation 2017. Now, page 80, your lordship will see
5 years as reader and associate.
professor, my lord, is 5 years of teaching experience in the specialty as reader/associate professor. Now, my lord, I am aggrieved from the, my lord, post of reader. If your lordship sees reader, if your lordship comes to reader, a bachelor degree in dental surgery from an Indian university with masters in dental surgery, diploma at national board recognized by the government of India on the recommendations of the council, and with 4 years of teaching experience. Lordship will kindly mark this one, man. 4 years of teaching experience in the specialty after post-graduation. Now, my lord, it does not specify that I have to have, my lord, teaching experience as a lecturer. It does not say that. Teaching experience. So the teaching experience,
No, you are now claiming promotion to which post?
I am, my lord, claiming promotion to the post of professor.
Professor.
On the
Now,
count.
professor says 5 years as a reader or associate professor.
Correct, my lord. Correct.
So there are 2 feeder posts or 1 feeder post known as reader or associate professor.
Well,
You are in the feeder post of associate reader.
Reader.
With effect from 24.
Yes.
So you complete 5 years in 29.
This is my case, my lord. What I'm trying to say, the bone of contention is this, my lord, page 70. My lord, I claim my promotion on, my lord, acquisition of teaching experience of 4 years in 21, my lord. 15/6/21.
That
My claim was, my lord, made at the time when the post was vacant. The application was forwarded for consideration. Nothing was done. Only in 24 this order has been passed, my lord. Immediately the principal has forwarded the application. Your lordship will kindly see the next page, my lord. My application was forwarded immediately
So
in the month of, my lord,
according to you, your promotion to the post of reader should have been antedated.
antedated, my lord.
Right.
Correct.
So that will require examination.
That will require examination.
Now, until and unless it is antedated, you
Yes.
don't satisfy the eligibility for the post of a professor.
Yes, correct.
Now, without prima facie arriving at a conclusion that satisfy the eligibility, will it be proper to issue direction to consider your papers?
No, can it be this way? In an identical case, my lord, I have annexed your lordship's order.
Yes.
Absolutely identical case. Your lordship directed to consider them, but to remain, my lord, in seal cover, subject to, my lord, order of the outcome of the
I don't
petition.
think this
If
was
your-
the issue there.
My lord?
This matter, this was not the issue.
My lord, in fact, my lord, so far as the present writ petition is concerned, lordship will see the prayer for a moment at page 24.
No, my lord, I am reading
I
it
will
out.
clarify, my lord,
Page 98.
24, my lord, prayer.
Page 98, your lordship will kindly see, my lord, from second paragraph. The applicant is aggrieved that her claim for seniority in the post of reader has not been given effect to in terms of the claims made, and as a consequence thereof, the applicant is aggrieved that she has not been considered for selection to the next higher post of professor in the Regional Dental College, Gauhati, in the department of so-and-so. According to the applicant, she meets the eligibility criteria and therefore her case should have been considered for promotion to the next higher post. But due to the base knowledge, the authority has not been even forwarded the relevant papers, including her ACR, and there is an
That you don't
apprehension
meet
that...
the criteria here, prima facie you don't meet the criteria.
No, I meet the criteria. Same case, my lord. The order was passed subsequently, not giving a retrospective effect.
That is a different issue. Here that retrospectivity is not even considered today, insofar as the feeder category of reader is concerned. There is no dispute that you are promoted on 24.
Yes, well, same case.
According to you, should have been promoted on 21 or 22, something like that.
21.
21.
15 June 21.
So you are now asking for your promotion to the post of reader to be antedated,
Yes, my lord.
so that you become qualified to be considered for the post of a professor.
Same case was there, my lord. That was not, my lord,
I don't know what you say, Mr.
I have annexed this order.
The same case.
Here,
Same
my lord,
case.
Because the
lordship will
dates
have,
are not available here.
my lord, in order to be eligible for a particular post, my lord, the rule will prescribe, my lord. Now, my lord, moment the person
No.
becomes eligible doesn't
No,
mean that
no.
he will have to be promoted, my lord. When
No, page 98, are the petitioner similarly situated?
Absolutely.
not similarly there, my lord, the issue was regarding the post of lecturer, initial, my lord.
No.
So
There
the
was some direction
petitioner
from the
wanted
court.
that, yes,
There was some direction from the court
yes,
to give her the benefit.
yes, that
Which
was not
there.
granted. That was not granted.
There was a
Only the
direction
amendment
from the
was there.
court
Lordship will see, my lord.
that the benefits of antedated seniority should be given.
Lordship will kindly see, my lord. Here,
Heard Mr. S.K. Talukdar when it comes.
no, my lord, there is an order of the honorable court saying that since, my lord, my consideration to the post of reader was not considered at the, my lord, relevant point of time, the DPC will, my lord, take a call in that regard.
Which DPC?
My lord, the DPC for the post of reader. Yes, but that was not done.
Well, that you have accepted, you're not challenging it.
That's why I was pointing to the
That
prayer.
order of the DPC recommendation and the consequential order of promotion, you have accepted it. You not challenge it.
Yes, that is correct, my lord.
Yes,
But
nothing is
But
there.
that of course will not foreclose your claim for antedated
yes,
to be examined by the court.
yes. My lord,
So
at
we'll
this
examine
stage,
it.
at this stage, what I'm saying, my lord, since the DPC, my lord, will be
You show us any material that there was some direction from the court or a decision by the authorities concerned that you should have been promoted prior to 2024, which order was not given effect to.
Yeah.
We will consider your interim claim.
no, that, my lord, direction is not there.
Not
I
there.
genuinely, my lord,
So
submit.
therefore, there has to be a finding as to your entitlement for antedated promotion in the post of reader. First, it is only after that there is a question of deciding whether you meet the eligibility for the post of a professor.
Yes.
In the event this court comes to a finding
Correct.
that yes, you are actually deprived of antedated promotion in a reader, consequential orders of giving you antedated promotion, assuming you are promoted later,
Yes.
in the post of professor can always be given.
My lord, what I'm trying to say, balance the equity, because once,
There is
my
no
lord,
equity here because
No,
prima
Lordship will kindly see.
facie you don't
No.
satisfy the
my lord,
eligibility.
if
As
my,
on date.
no, my lord will kindly see, if my lord plea is accepted by this honorable court eventually, then my lord non-participation in the, my lord, DPC, my lord, will cause prejudice to me.
No,
my lord, if they consider my claim.
Are you suggesting the court is powerless to direct having a review DPC? No. If we find that yes, you are entitled and wrongly deprived of, direct a review DPC.
My lord, even if my case is considered and kept in my seal cover, as your lordship has directed in the other case, my lord, no prejudice, my lord,
You
is
are trying to draw analogy with this order without going into the facts of that case. There was a judicial order that the benefit has to be given. That was not done. And in that view of the matter, because unless an order is revisited by way of an appeal or a review, that order remains. There was no explanation why the department was not considered. I don't, subject to correction from Mr. Gugoi. This is what I recollect.
On
I don't
top of
know.
that, my lord, so far as the rule is concerned, my lord.
But on, if the benefit is given, then they satisfy the eligibility criteria. Here there is no order against you, in your favor.
Yes, that is correct. There is no order.
Then you said you have accepted on 24th. You'll
No
not put
challenge,
that
sir.
under challenge.
Correct.
You complete 5 years in 29. How are you prejudiced by, not putting your name in the seal cover? Till that time, the court decides whether you are entitled to antedated promotion or not. Your angst lies in the post of reader, essentially.
Yes, essentially in the reader. Correct.
Then not in the post of a professor.
Not in the post. Correct.
And my lord, so far as the rule that has been relied upon by the petitioner herein, my lord, that rule is not applicable for the promotion to the post of professor. That has been clarified by the Dental Council of India to the principal of the Regional Dental College. But it is a
For
MD
now,
rules.
we'll issue notice.
Right.
Issue notice. Is there any representation that your post should be considered for antedated promotion? There is representation pending.
My lord, I think pending, my lord, but I don't know whether
Heard
I'll
Mr.
clarify
S.K.
that.
Talukder, Council.
that is pending, my lord, 85.
Mr. B. Gogoi, the studying petitioner lady appearing for all.
All the
So the way Mr. Public Service. The opinion of one of the petitioner is presently serving the Regional Dental College
My lord, in the reason that
as a reader.
reader.
What? Oral pathology.
My lord, the specialty
Microbiology.
is, my lord,
Huh?
oral pathology, microbiology, and forensic
Microbiology and
odontology.
Forensic odontology. So page paragraph. Petitioner is agree that his case for promotion to the next high post of professor is not being considered by the department. Is the claim of the petitioner that while the petitioner was promoted to the post of reader, as far back as where is that order?
My lord, the promotion order, your lordship will find at page 70, my lord.
70.
70, my lord.
Order dated 24
19/9/24, my lord.
19/9/2024. Is the claim of the petitioner that means promotion to the post of reader ought to have been antedated, ought to have been considered with effect from the year 2021.
15/6/21.
15/6/2021 has yet satisfied the eligibility criteria for promotion prescribed by the rules, and there is no quarrel on the fact that there were vacant posts available at the relevant point in time. Stop his representation, his prayers made before the authority were not considered. It's the claim of the petitioner that had he been considered for promotion to the post of the reader with effect from 2021, 17/6/2021, might have satisfied the criteria specified under the rules for being considered for promotion. So, professor, as the department is presently considering. So, he therefore submits that a respondent be directed to forward the papers relating to the petitioner before the PTC, and his case be considered and placed under seal cover during the pendency of the litigation. Well, Mr. Gogoi on the other end submits that prima facie the petitioner does not satisfy the eligibility criteria specified under these ones. The rules specify that has to serve for 5 years in the post of a reader or associate professor. Stop since the petitioner is promoted with effect from 19/9/2024, he becomes eligible on the year 29, September 29. Therefore, as on date, there is no, since he does not fulfill the criteria, there is no necessity for the department to consider his case for the next higher post. So, considering the submissions made, this issue returnable to since question of eligibility of the writ petitioner will depend on these claims made for antedated promotion to the post of reader under the regional dental college. The claim of the promotion to the post of petitioner, to the post of professor, be considered upon such orders as may be passed on the claims made by the petitioner with regard to his promotion, his antedated promotion, to the post of a reader. Yes, and the consequently to the post of professor. And thereby making him eligible for being considered for the post of professor. Professor. How many posts are there?
There's not been mentioned in there. I'll file my affidavit when I'm ready.
At this stage, that is all we can do for you.
My lord, if my prayer, my lord, is, my lord, accepted by your lordship, that is not going to prejudice anybody, even the department. It will be kept till cover, it will not be open. Then, my lord, I think I get the.
Provided you convince us that your promotion to the post of reader was required to be antedated.
My lord, my lord, can it be this way? Lordship will take up it on motion, will file an affidavit. My lord,
Motion it won't be possible. Immediately after reopening, lordship will fix, I will file my affidavit.
You will have to satisfy the court that notwithstanding vacancies available, the non-consideration of your case
Yes.
was contrary to law by the department, and therefore you are entitled to be antedated.
My lord, I have already shown your lordship.
My lord, that rule is not
document.
applicable, my lord. That's my specific instruction from the Dental Council of India. I can place it now, my lord.
No, if my learned, my lord,
Yes.
friend says that the teaching
rule is
experience
not-
is not 4 years, if it is different, my lord, then I have no case. My lord, submission is teaching experience of 4 years
So
shall be counted.
let him file the response.
Some interim order, my lord.
What
Can it be?
interim? What interim do you want?
One post, my lord, if there are more
First
than
of
one.
all, you will have to show that he's eligible.
My lord, can it be, your lordship may take up on Friday, my lord, further instruction I'll obtain. Can it be on Friday? Can you? Monday. I'm deeply
Monday for consideration of interim prayer.
I'm deeply aware.
Yes. Yes, what is it? What is it?
Well, here says, my lord, this service was not confirmed, my lord. So, yeah, the letter was written to the joint.
What is your case, Mr. Singh?
Hello, the petitioner was a engineer in the PWD department. He died in earnest while serving in the National Highway, Malab, one truck hit him. So he has served at least 18 years. Therefore, he has filed this, the wife has filed this present writ petition, claiming all the claims of the
Family pension.
family pension. Malab. Meanwhile, during the pendency of this matter, she obtained everything except the DCRG, Malab.
Now the government is saying in their affidavit in opposition that since I have not served, the petitioner husband has not served 20 years, so she is not entitled. So I have not found anything. DCRG, man.
The other family pension balance already released.
I have not found any
No,
provision
what
that
was the order passed in the, by the district judge?
district judge pertaining to my lord. There was
There was a suit for divorce.
there was suit for divorce.
That was dismissed or allowed?
Dismissed, my lord.
Dismissed.
So mat appeal was pending before this on court
So it
division
is-
bench. That
It is abated now. Who
yes,
preferred?
ma'am, that abated.
Abated.
So her position was a wife, my lord. So being a wife, she has been happy.
Now for family pension, 1 year service,
Family was already received, madam.
received.
Yes, not DCRG part. DCRG.
DCRG.
Service was not confirmed, madam. This is the word instruction, madam. And there's a government letter also we enclosed.
PWD service not confirmed.
My lord will take up the instruction that my friend has placed before your lordship.
Such a long instruction, you tell us summary of the instruction.
My lord, I
Yes.
just from para 2, my lord. The district government servant date of appointment was 94 and the date of death was 28/5/2012. Meaning thereby 18 years, 3 months,
Was
and
it
4 days.
confirmed or not?
So not confirmed.
Not confirmed.
Not confirmed, my lord.
Why was it not confirmed? Why was it not confirmed?
My lord will take up the instruction. Same instruction on last page, my lord. My lord, he was in a temporary service, my lord. The government of Assam has decided that the temporary service of not less than 20 years without being confirmed in any post may be allowed the benefit. He will get the family pension, but DCRG part, my lord, he will not get money.
Yes.
That is the reason why I am relying on the decision rendered by this on the division bench of our High Court. In Doli Borpuzeri case, ratio may be applied, my lord, wherein the petitioner therein, my lord, was on a contractual basis and was not confirmed.
No, this is not to DCRG.
This is not the DCRG. In fact,
Your other claims of family pension has been released.
that has been given.
So therefore, it can't be said that they have entirely rejected your claims for any benefit. It's not a case that they have rejected your claim for benefits. What does the rule say?
Nowhere I have found that since he has served only 18 years, so he will not be entitled for DCRG, my lord. I have not found any rules, my lord, in the council. And friend will guide this on the court, my lord. Right.
You have given family pension. Is it permissible for an employee who is not confirmed?
Family pension, my lord, in case of temporary government servant with less than 20 years of qualifying service without confirmation at the time of retirement, death in service, prescribed rules as laid down in the APS 1969 may be followed.
Where,
So,
where?
My
Where
lord,
is that?
my lord, that instruction will the last page.
No, under the rules you show us, under what rules? Under what rules? You have referred to rule 142.
My lord, it is not our case that my lord, we forwarded. It is the accountant general, my lord, who declined, my lord.
Yes, accountant general.
It's our instruction, the family pension is entitled, madam. So it
No,
was
no.
granted.
Under what provision?
Even one of the, one day also, then also they enter, there's a office memorandum is there, madam.
Where is that office memorandum? What office memorandum?
Yes.
Submission is that since he has not rendered from here, only calculation will be, there will be a difference in the calculation. As stated in the rule 135, ma'am.
135.
135. That from retirement ratio. Officer who has completed 5 years qualifying service may be granted an additional gratuity not exceeding the amount specified in subgroup 3 when he retires from the service and is eligible for gratuity for pensions under rule 101 and 111. If an officer has completed 5 years qualifying service, dies while in service, a gratuity not exceeding the amount specified in subgroup 3 may be paid to the person or person on whom the right to receive the gratuity is confirmed under rule 136. So my humble submission is that the calculation there will be difference in calculation. As per the service has been rendered, time of service has been rendered.
Where is it written?
Rule 135, 1, subclause 1, an officer who has completed 5 years qualifying service may be granted an additional gratuity not exceeding the amount specified in subgroup 3.
What is qualifying service?
It is saying that it's 5 years, again in 101.
Where is the circular? Find out at 2 p.m.
Yes, ma'am.
Right.
Definition of Madam Chair. The petitioner, my lord, while serving as the EBA, retired from service on 31/8/2015. On 2 occasions, his pension paper has been returned. Subsequently, after correction of pension papers, all the my lord, statements of his service of accounts has been resubmitted. Thereafter, pension has been granted as per Annexure F, page 29. My lord, here at page 30, Annexure G, there is a recovery of amount has been mentioned as 63,168 at page 30. The column serial number 3, recoveries, 63,168.
This is for what?
Page 30.
Recovery on what account?
Recovery of excess payment.
Access payment.
Yes, ma'am. They have said the excess, there is from death come retirement gratuity. There is an excess amount has been mentioned. So the pension assistant accounts officer of pension, that accountant general office has mentioned that amount 63,168 as a excess amount, ma'am. From death come retirement gratuity. My lord, as per my lord, is already retired from service, and my lord, that as per my lord, Profit must see that decision, my lord, that post retirement, my lord, that kind amount cannot be recovered.
What is the stand of the respondents?
Respondent saying, my lord, that stance of the respondent is that there is a recovery. And another, my prayer is that while resubmitting the pension documents again and again, the department has, your lordship will find,
So which is the parent department?
parent department is the PHE department.
PHE.
Yes.
Is there any finding that this was on account of the
No,
petitioners?
no such point. Now, my lord, one more prayer is there. While resubmitting the pension papers, when they have, on second occasion, when they have filed the details of statements of accounts at page 20, your lordship will find. Page 20.
Yes.
That is, my lord, paid loan of statement of senior account retired with the preference so and so, so and so, so and so. So, my lord, details of statement of accounts, your lordship will find, that is page 24. Total is 40 lakhs, 40 lakhs, 43,135. Maybe lordship got money. Total, my lord, paid. The amount to be paid, sorry. Then, well, after that, after re-verification of the amount, sorry, this was after re-verification. Now, before re-verification of the amount, your lordship will find page 28. Total amount paid is 36 lakhs 91,826. This is my lord, before there is a before payment is made, and after payment is made, amount should come as 40 lakhs 43,135. So there is also an amount of arrear amount to be paid to the petitioner by the department. There is also one more prayer in the writ petition.
Yes, PHE.
Under the recovery part, I want to oppose because Rafiq Masi covers the field. And that apartment ADR, my own authorities, my lords. There is a calculation error on page 24 and page 28.
Come to page number 48. There are three of your affidavit.
Of my lords, the affidavit reply.
This is the reply,
My lords.
but there is no affidavit
No affidavit.
by the department.
Still did no affidavit. But can this matter be taken up next Tuesday, man? I'll try to obtain some instructions. Not try, but I'll take some instructions. Recovery department, that is okay, but Rafiq Masi and the other formal decision of the government. So it is not his fault.
We
Apparently,
close it directing the department to examine his claims for recovery
Well.
and pay it within a time bound period. The area salary
Well.
and no recovery
Well.
because you are a
No
grade 3.
Yes,
Because
great.
as on date, you have not brought any material to show that he was responsible.
Well, that is that.
Heard counsel.
I appear for
The writ petition is filed by the petitioner, praying for direction for setting aside the impugned letter number so and so, dated so and so, page number 9. Issued by the senior accounts officer, Office of the Accountant General, for recovery of the amount of 63,168 of the retirement dues. Further prayer of the petitioner is to make the payment, the direction to the respondents for payment of 3,51,309 as increment area. So, the claim of the petitioner that petitioner rendered his service and at no occasion that during his service was confronted by the respondents that there was any overdraw by the petitioner, which also recovered in terms of the communication of the Office of the Accountant General. Stop. Rather, according to the petitioner, he is entitled for a payment of 3,51,000.
Yes, madam. 309.
309 as increment area. Respect of the writ petition. Stop. Then, pursuant to issuance of notice, Accountant General has filed, Accountant General's office has filed an affidavit stating that there were some anomalies found regarding fixation of pay of the writ petitioner, and therefore the pension papers were initially returned back, requesting the administrative department for rectification. Stop. Pursuant thereto, the same papers were again sent back. Upon the calculation by the Accountant General, it is found that an amount of 63,168 is found to be recoverable from the pay and allowances, including leave salary of the petitioner. The department has not filed any counter affidavit opposing the claim of the writ petition. Stop. The petitioner has filed a rejoinder affidavit to the affidavit filed by the Office of the Accountant General, reiterating its claims. Stop. There is no scrutiny of the affidavit filed by the Accountant General. Does not reveal that claim of overdraw of pay by the petitioner was on account of the shortcoming was on account of the petitioner. Stop. There is no submission by the DHE department that any amount which was any error in the fixation of pay with respect to the writ petitioner, any action can be attributed to the petitioner. Stop. In the absence thereof, and taking into consideration the fact that the petitioner rendered his services as LDA,
UDM.
UDA, which is a grade 3 post under the government of Assam. The principles laid down by the apex court in Rafiq Machi, reported in so and so, are equally applicable. Since there is no finding by the administrative department or by the Office of the Accountant General that there was any default or fault on the part of the petitioner leading to excess royal of pay, the said amount of rupees so and so shall not be recovered. For pension paid to the petitioner shall be released forthwith without further delay, if not otherwise issued. Regarding the claim of the petitioner for arrears of pay
Pay and salary.
The respondent department, more particularly
Executive engineer.
direct the chief engineer, number 2, to examine the claims of the petitioner. Is it respondent 1 or 2? Secretary or chief engineer? Who does the pay and recovery?
One of the 3 money.
No. The chief engineer.
Chief engineer.
Respondent 1 and 2 are directed to examine the claim of the petitioner, and if any amount is found payable to the petitioner, the same shall be released as expeditiously as possible within a period of 90 days from the date of receipt of a certificate of his order disposed. Mr. R. Gugul appears for respondent 4 and 5. R. Gugul appears for respondent 4 and 5. D. Gugul for PH. Interim order, any stands merged.
Yes.
Pending ayes are also dismissed.
Applied.
I'm acting on behalf of Gauhati. This matter is relates to the termination of appointment during the probation period. The petitioner was appointed as constable in CISF, and during his probation period, he was terminated due to unfit color vision.
Now what is left? What is left now is terminated when?
I'm terminated.
Page number?
Page
Order?
number. Termination order is at 26. Termination order is at 28.
28. 28 has been found unfit.
Unfit.
Where is the report of the medical? RME, DME? Where is the DME, RME?
Annex 3 of affidavit in opposition. Page number 25
25.
of affidavit in opposition.
So what is wrong with the order?
Wrong order means I was terminated under the rule 26(4) of CISF rules, which provides that I was suppressing the fact that I have had the issue of unfair color vision, which is not true. I was not aware at that time.
But if you have color vision, then is it a ground for rejection or
Yes.
termination?
Yes,
Under what provision?
Madam, kindly see my affidavit in opposition page number 31, madam. That is office number in the button.
Office memorandum.
Yes, madam.
Yes. What does it say?
My lord,
This is
like-
an application, not office memorandum.
No, but new policy from page number 31 annex.
Huh?
Page number 31 annex, the last one, madam.
Page number 31,
Annex 6, madam.
chapter 6.
Here for me, correct?
Yes.
My lord, kindly come to page number 32, Roman 3.
1, 3.
My lord, it is however clarified that this present direction will only apply prospectively. Those persons required earlier and thereafter found to be colorblind will not be boarded out on account of that. But it is reiterated that any person required herein after if the found colorblind, even after recruitment shall promptly be boarded out of the service, keeping in view of the direction of the honorable court.
When was he recruited?
He was recruited in 2017. And this
2017.
is yes, madam. And this is the
So during his
2013.
medical, he was not found.
during his medical, he was not found.
Then
Then, madam, in his application, madam, his appointment letter, kindly come to page number 22 of his petition, madam.
22.
Yes.
Yes.
Was in probation at that point of time, madam. Clause 2, Roman 3 and 4, madam. He will be probation for a period of 2 years. Number 4, the appointing authority may discharge you from the service at any time during the period of probation if in their opinion your work or conduct during this period is considered unsatisfactory or so that you are not fit for permanent appointment. He is not fit for permanent because of color vision, my lord. This is one of the clauses. Yes, not fit for permanent appointment, my lord.
Where is it written?
That is in page number 22 of the Picnic edition. Clause 4, Roman 4, 2 Roman 4.
No, we are not asking you there. We are asking you that at the time of his entry, was there no medical done?
The medical was done, my lord, at that time.
Then he was not found.
No, at that time he was not found, my lord. But during the
What do you say? You are declared to be colorblind. Third, counsel for parties, this requisition is filed by the petitioner challenging its termination order. Dated
dated 8/9,
5/9.
8/9/2007.
Page number?
Page number 28, Annex 9.
What is the 30?
Appeal. This is appeal. This is the appeal. Third and appeal.
No, 30 of the affidavit.
No, my lord, 29 of read petition, my lord. This is the order, termination order.
29.
Yes, my lord. Annex 9.
29.
Yes,
By order dated
8/9/2007.
8/9/2017, whereby the petitioner was terminated from service on the ground of defective color vision. As per the opinion of the Review Medical Board. So, petitioner was appointed as a constable GD in the CISA with effect from 5/4/2017. Stopped. Thereafter, he was serving under provision. Stopped during provision period. He was medically examined in the Review Medical Board. Upon examining the petitioner, found him to be colorblind, and as a consequence thereof, the petitioner was boarded out of service, was terminated by the Board of so and so. His appeal, he filed an appeal.
Yes.
Appeal filed before the authority also came to be dismissed. The petitioner has filed the present petition. So, state the respondents have contested the matter by filing their counter affidavit. Counter affidavit. Respondents have stated that even in the order of appointment, there is a provision that if the petitioner is found to be petitioner may be discharged if his work or condition conduct is found to be unsatisfactory or that he is not fit for permanent appointment. So, petitioner has not been able to make out a case in support of his contention that the findings of the Review Medical Board are contrary or in conflict with any other opinion rendered by specialists. Stop. Book 26 of the CISA rules 2001 reads as under as per rule 4. Petitioner was terminated on the ground of furnishing false or incorrect information at the time of appointment as a member into the force. So, claim of the petitioner is that there was no false furnishing of information. Stop. However, Court of petitioner suffers from color blindness. So petitioner has not been able to support his contention by any independent finding by any specialist suggest to the contrary. Under such circumstances, this court does not find any merit to exercise its legal function in respect of the claims made by the petitioner and interfere with the prohibition order. So, the petition being devoid of merit, same stands dismissed. Interim orders remaining stand vacated, pending hires are also dismissed. MSA Gayan, learned CGC for the respondent.
The matter only taken after vacation and for disclosure and admission hearing.
Disposal admission hearing. The pleadings are complete.
Yes,
No, we have not filed our affidavit.
We have not filed. What is the claim here?
Claim under the appointment of this Anganwadi worker.
Not body work. Mr. B. Sinha for the petitioner, Mr. CTS Barua, London State Council. PS for the state respondent.
120.
Submits that the affidavit has not been filed. Mr. B.K. Sharma, appears for responding
ma'am.
court. You have filed your pleadings.
Yes.
Let the state endeavor to complete its pleadings. They release this matter for admission in the month of August on a date to be fixed by the minister.
Pertaining to selection for the post of Anganwadi worker. The petitioner has put to challenge the eligibility of the respondent number 5, Lordship. Your Lordship may come to annexure.
We'll come back up at 2.
Lordship.
Yes, pleadings are complete.
Lordship, pleadings are
Readings are complete now. This
The
can be.
parties are represented. There is a private respondent.
Lordship,
M54 supplementary list, my lord. Someone respondent has mentioned it, my lord, and fixed it after vacation. It's an important urgent nature, my lord, without informing me, my lord.
Order assignment. Who is the respondent?
My lord,
You inform him. Before rising, if you can inform him, we'll take it up.
Alright.
Yes. Yes.
matter pertaining to selection of Anganwadi. Initially, Lordship, may kindly come to annexure 2, Lordship, at page 23. Pursuant to the advertisement, Lordship, issued, the petitioner and the private respondent there applied for the post, Lordship. Then a valid list for the Anganwadi worker was published at page 23, Lordship, right side, 140 number Singimani part. There, Lordship, the private respondent number 5, Lordship, she has been placed at serial number 1. And we have been placed at serial number 5, Lordship.
You are referring to annexure 2.
Lordship, page 23.
So serial number 1 is
Lordship, Anima Khatun, she be respondent number 5.
5.
Her candidature was put to challenge by the petition, who is at serial number 5, on the ground that she is not a resident within the survey area of the Anganwadi Center. That was clarified by the council appearing for the government by producing the survey register, Lordship, before this honorable court. And Lordship, it was seen that she is within the survey area. So, Lordship, that ground of ours, we do not have any ground on that aspect, Lordship. So, Lordship, by the permission of-
Is she a resident or not a resident?
Lordship, she is a resident, Lordship. Our
She is a
challenge
resident.
was that she was not a resident, Lordship. And this is the criteria required as per the government notification, Lordship, which is at page annexure 3, Lordship 24. Mandatory requirement is that she has to be a resident within the survey area. Now, Lordships, since that ground, we no longer we are in that ground, Lordship. So we have filed an additional affidavit subsequently, Lordship, on 12/5/2026, bringing on record the educational qualifications.
No, but they have stated that respondent 5 is a local inhabitant.
Inhabitant, Lordship.
yes, ma'am.
That's what Lordship, we had stated that she is not, Lordship.
Hmm.
Lordship, then
the survey register was produced and it was shown that she is a local in. That's why Lordship on that ground we do not have any case. Lordship then Lordship with the permission of the Honorable filed one additional affidavit to bring on record the educational documents pertaining to the respondent number 5. Lordship, during pendency of this writ petition, Lordship, we had filed a complaint before the Director Social Welfare Officer, that is the respondent number 3, at page 74 of the additional.
What is the defect in her education?
Lordship, after verification, Lordship, it was intimated by the principal of the concerned school, Lordship, that she has not appeared bearing such roll number. No such candidate has appeared from that school, Lordship, respect to her higher secondary certificate. So, Lordship, my humble submission is, Lordship, since the matter is already pending before the respondent number 2, Lordship, that is the director. So, director may take a final decision, Lordship, but just that these documents may be taken into consideration, Lordship, while deciding the case.
Yes.
My lord, I am respondent for 5.
Heard counting for the parties. Petitioner is assailing the appointment of respondent 5. 5's appointment to the post of Anganwadi helper. Worker. In which Anganwadi center?
Lordship,
277 number Singimari Part 2 Anganwadi center.
140.
Huh?
140.
140.
Number Singimari Part
140 number Singimari Part 2 Anganwadi center, the district of under Gauripur ICDS.
Lordship.
Gauripur ICDS project, the district of. So, pursuant to the advertisement dated 3008/2024, both the petitioner and the respondent 5 applied for the offered their candidatures. So, in the terms and conditions of the advertisement, is provided at clause 1 that the candidate or the Anganwadi worker for the mini Anganwadi center or Anganwadi helper should be a permanent resident of the concerned Gaon Panchayat and the functional area of the concerned center. The age of the candidate should be between 18 and 44 years. And the educational qualifications should be high secondary or class 12 pass. So, the petitioner has filed this petition primarily challenging the appointment of the respondent 5 ground that she is not a permanent resident of the so-and-so area. So, the respondents have contested the respondent state as also the respondent 5 have contested the matter. Their affidavit filed by the CDPU in the respondent 4. At para 5, it is stated that respondent 5 is a local inhabitant of within the jurisdiction of 140 number Singimari Part 2 Anganwadi Center. As per the survey register, ID house number 55 of the. So, said register was also produced before the court in support of the contention.
142.
So, thereafter, the petitioner, with the liberty granted by the court, filed an application, additional affidavit, to bring on record that the respondent number 5 does not have the educational qualifications of HSSLC passed. So, this stated by the petitioner that in response to a communication issued to the headmaster of school from which the petitioner claims to have passed, namely the headmaster and principal. What is that? Rokakhata Model High Secondary School in Hakama, Vilasipara, in district of Dhuli. Where there is a categorical statement by the principal that the respondent number 5, namely Soen Onima Khatun, daughter of Monser Ali and Jamima Bibi, never appeared in the high secondary examination bearing roll number 0418 and number 20045 from this school in the year 2020. So this particular communication was addressed to the CDPO, Gauripur ICDS project Dharamshala. So it is submitted that you have filed a representation.
Prior to approaching this,
No, after this information,
after this information,
the state respondents do not dispute the same, that the information sought for by the CDPO Dhubri with regard to the information sought for by the CDPO Dhubri from the principal of so-and-so school in respect of the eligibility of the private respondent number 5. So, this being the position, this court is of the view that for ends of justice, it is considering that there are questions of facts involved. The petition can be closed with the direction to the director, social welfare. Is it social welfare?
Now, my child and women.
Which has been renomenclatured as Director of Child and Women Development.
My lord, women and child development.
Women and Child Development, Government of Assam, to call for all relevant reports, respect of education, respect of the grievances ventilated by the petition regarding the eligibility of respondent number 5, and thereafter pass a detailed order. Before the director passes such an order, opportunity of hearing to all concerned must be afforded. Needless to say, any such order that is passed, copies thereof will be served on the contesting parties. So, if after examining the matter, the director comes to a conclusion that the private respondent does not fulfill the requirement as advertised, then consequential orders may be passed for appointment of the petitioner if she otherwise fulfills all the criteria specified. With the above observation, the petition stands disposed of. Let this exercise be carried out within 60 days from the date of receipt of a certified copy.
My lord, let them file a presentation for the director.
Not necessary. Directing spending all the matters, the papers will be called for from the office of the city.
My lord, let them submit the document before the CDPO.
The writ petitioner will furnish a certified copy of this order along with the copy of the writ petition with all includes, including the affidavits filed by the protesting parties before the director. And the director will thereafter call for all necessary documents required from the office of the CDPO, Vilasipara Dhubri, Gauripur, and pass appropriate orders as director. Mr. Ardhor for the state, Mr. Riti Sarkar for respondent number 5.
I mean, I think 19.
Huh?
Rule 142 of pension.
I go to given number 142.
Yes, madam. Here says, madam, if government servant after rendering minimum of 7 years continuous service dies while in service, the family of such government servant may be granted a pension at the so my lord. So my lord, as per
One
this-
42.
Yes, my lord. Rule. So as per this, my lord, family pension was granted, my lord.
142.
142 rule, my lord. It's also reflected in my instructions, my lord.
What is there? 142.
If government servant after rendering minimum 7 years continuous service dies while in service, the family of such government servant may be granted a pension.
Right.
So family pension is granted, madam. And DCRG is part, madam. So far DCRG personal qualifying service is required, madam. The rule 36, rule 136, madam, 6, madam. Rule 136, 2, madam. An officer shall, as soon as he confirm or complete 5 years qualifying service, either confirm or 5 years qualifying service, make a nomination conferring on so and so sensor, and on gratuity and everything will be received, my lord. And so far, rule 31 speaks, my lord, condition of qualifying service, my lord.
One 30.
My lord, 136 2, my lord, 32, 36 2, my lord, speaks about the, my lord, the in officers shall, as soon as he is confirmed or completes 5 years qualifying service, either confirm or completes 5 years qualifying service, my lord, then he will entitle, my lord. And so
No,
far,
but you tell me that how you are granting family pension?
yes,
You
my
know,
142, my lord.
142 talks about officer confirmed. 142.
142.
Government servant.
Yes, man. After entering, my lord, he is the, my lord, his service is not confirmed, my lord.
Then how are you granting him family pension?
My lord, only those who are, my lord, those family business, they are entitled, my lord, but this year is not.
That's what we are asking you. Under what provision are they entitled?
My lord, his government servant is his government servant. Service is not confirmed, that is there. And qualifying service is concerned.
This is not what 142 says. You show us that 142 is applicable to all government servants irrespective of their confirmation. It says government servant. Who is a government servant?
My lord, there is the qualifying service, my lord, is there, my lord, rule 31, my lord.
Who is a government servant? Yes, Rule 31.
Yes, my lord.
Does he satisfy Rule 31?
31, my lord, is government, my lord, that is from the department, my lord. Department will inform my lord whether his service is confirmed or not, my lord.
Right. Department says it is not confirmed. You have allowed family pension.
Yes.
But you refuse to give DCRG.
My lord,
Why?
DCRG is, my lord, DCRG speaks, my lord, when entitlement of DCRG is, my lord, these either service has to be confirmed or qualifying service.
But does 142 can be interpreted to say that even if it is not confirmed, they are entitled to family pension?
My lord, yes, my lord. So far, because he is working as junior engineer, my lord, and so far in litigation is concerned, my lord, there is no annexes, my lord, regarding the religious service, my lord.
We are not convinced with your arguments. 142 does not lay down any distinction between confirmed and non-confirmed. Does not say anything. It refers to government servant.
Yes, my lord. That is,
Government servant would be
136
relatable to 31.
Well, 136 speaks, my lord, 2 speak the who are entitled for DCRG. 136 it's defined, my lord, this who are entitled for the family DCRG, my lord, 2, my lord. And officers, as soon as he is confirmed
Or complete
or
5
complete 5 years qualifying service. Any government servant, my lord, as per 142, they will during the period of this 7 years complete, my lord.
So he is not confirmed, but he completed 5-year service.
Yes, qualifying service. Qualifying service required, my lord.
So
And
qualifying
qualifying
service
service speaks, my lord, is from rule 31, my lord.
31. What is qualifying service?
Service must be under government, and secondly, employee must be substantive and a permanent post, my lord.
So that has to be ascertained by the department, my lord, because in the writ petition, my lord, there is no such annexes, my lord, regarding the appointment of the husband of the writ petitioner. Only one letter, my lord, is there in last page annexes, my lord, page 65. You are not qualified.
No, my lord, that
There is no annexes, my lord, regarding
Rule 3130 here, that has not been read out. The service must be paid by the government. Provided that the governor may, even though either or both of the country.
You can't file an application before governor.
No, my lord, this rule 135, read with rule 111, my lord. Place
135.
DCRG 135.
135, yes.
Yes, madam. That come retirement gratuity. An officer who has completed 5 years qualifying service may be granted an additional gratuity not exceeding the amount specified in sub-rule 3 when he retires from the service and is eligible for gratuity or pension under rule 100.
What is qualifying service? 31 minutes. What is qualifying service?
That he must be the government servant, the employer. He is holding the substantive post, my lord. Only thing is that I have not been made permanent, my lord, because it is the government who will make it
Kindly
permanent.
come to 31 condition number 2. I mean, there is no documents when I petition regarding his service. You satisfy 1 and 3. You don't satisfy.
And again, 111.
111.
There is an OM, my lord. OM dated 19 November 1998.
Where is the OM?
My lord, 19 November 1998.
November
19 November 1998.
19 November 1998. My page is 120 minutes. 19 November 98. Yes.
There is a provision under subclause 9 that come retirement gratuity. As per this OM also, that come DCRG, there is an entitlement for the only thing that rule 31.
Which provision in the OM reflects that it is applicable to employees who are not.
That is the reason, my lord, I am taking aid of that Dolly Borpujari case. The ratio can be applicable, my lord. There also the petitioner was not.
Dolly Borpujari case, the
was not
government
permanent,
rejected their claim for pension.
Pension. Wherein there he was, the petitioner
So
was not
therefore,
made
we are
permanent.
asking you, we are asking the respondent, and you have not been able to support your argument that you are entitled to family pension. The family pension has been granted on the same conditions.
Yes,
But DCRG has been rejected. Then
only ground that I have not been made permanent. So he has served more than 18 years.
that is irrelevant. You have to tell us that there is some law, some clause they have refused to give you because you are not confirmed. You want to file a representation before the governor, you want to do that.
Your lordship may dispose upon that ground only what they have.
Heard learned counsel for the parties, this petition is filed with the petitioner claiming DCRG, other benefits payable to her on account of the services rendered by her late husband, late Prokhanto Kumar Priya, who had rendered services under the PWD as a junior engineer and who subsequently died in a road accident during his service period. So, the petitioner has been receiving the family pension payable by the respondents. However, the CRG claim by the petitioner has been rejected on the ground that the husband of the petitioner's services were not confirmed. Although he had put in 18 years plus
18 years plus.
service. Stop. The respondents, the learned counsel for the petitioner has pressed into service the judgment of a division bench of this court rendered in Dolipur, Pujari. The respondents have contested the matter by filing any affidavits.
Yes, I filed it.
Affidavits, particularly by the accountant generals. Where
Paragraph 5, my lord.
at para 5 of the said affidavit, it is stated that GPF and family pension has been finalized by the number so and so dated 14/10/2015 and by communication dated 18/11/2015 and FPPO number so and so, the same was issued the petitioner. Stop. However, since the net qualifying service of the deceased government servant, i.e., the late husband of the writ petitioner, is less than 20 years and not confirmed, the death cum retirement gratuity is not admissible. And the same has been intimated to the administrative department, namely the PWD, Building and National Highway Department. PWD not filed. Mr. Rard Hall, learned standing counsel for the PWD, submits that department has no objections, but the objections are raised by the accountant general's office. Pleadings have been perused. The learned submissions of the learned counsel of the parties have been completely considered. So the respondents, accountant general, have raised the objection that in terms of rule 136, 135,
136(2), my lord.
136(2), the petitioner is not entitled. Petitioner's husband, services rendered in respect of petitioner's husband was not confirmed, and therefore she is not entitled for DCRG.
Or not completed qualifying service.
As the qualifying services have not been completed. So qualifying services are prescribed under Rule 31 of the Assam Services Pension Rules. So the judgment pressed into service by the counsel of the petitioner is in respect of the petitioner there, the appellant therein who was denied the pensionary benefits after rendering services in under the Assam Official Language within bracket Translation of Central Laws Commission. Stop. The division bench held that by referring to the judgments of the apex court, held that interfered with the findings of the single judge dismissing the writ petition, that the appellant was not holding a substantive post on permanent basis and therefore disqualified under Bill 31 to receive pension. It was held that the appellant therein was holding a post on substantive and permanent basis, and disqualification under Rule 31 not apply to the services. Yeah, stop. Coming to the facts of the present proceeding, it is seen that there is no dispute that the petitioner had rendered more than 18 years of service, but the same was not confirmed. Family pension granted to the family pension granted to the petitioner was under the family pension scheme as prescribed under Rule 141, 142, the Assam Services Pension. However, the counsel for the petitioner has not been able to substantiate his argument that not extending the petitioner rendering the services for more than 18 years and not and confirmation cannot be a hurdle for conferring the benefit of PCR, the legal year of the government servant in the presentation. So, the judgment of Dolly Bolujari referred to by the petitioner does not come to the aid of the petitioner in the taxes by concern. So, the petitioner, the counsel for the petitioner, however, submits that under Rule 31, which prescribes the qualifying service of government servant, the governor has the power to relax any of the provisions subject to such application being made. So, counsel for the petitioner therefore submits that he be permitted to file necessary application for the administrative department for relaxation of the conditions of the Assam services. So, that view of the matter and considering submissions made, the petition stands closed, permitting the petitioner to file necessary applications to the respondent number 1. This commissioner and secretary or special secretary? Commissioner and special secretary to the government of respondent number 1, which is now redesignated as commissioner and special secretary to the government of Assam, PWD, National Highway and Buildings Division. Building and Energy. Stopping any such application is filed within a period of 30 days from the date of receipt of certified copy of this order, along with the copy of this order being forwarded with the representation form. The said office of the Special Commissioner and Secretary, Building and National Highway, forthwith take steps to forward the same for exemption as prescribed under Rule 31 to the appropriate authority. So, the appropriate authority thereafter will consider the matter and pass appropriate order within 90 days from the date of receipt of such an application that is forwarded by the Commissioner and Special Secretary. This proposal. Interim orders, if any, stand negative, pending ayes are also dismissed.
My name may be.
Mr. S.K. Medi appears for Accountant General, Mr. Radhor for PWD. Mr. D.K. Singh for the.
Just finding a reply, so it is ready by tomorrow, we are finding our reply.
MSR Devi,
Settlement for final disposal on Tuesday lawsuit, because.
coming Tuesday.
Yes, lordship. Because.
Have you not seen the notification?
Yes,
Motion
motion debate lordship, as per my instruction, by lordship last June, lordship, they are going to liquid recruitment process lordship.
What happened, my lord, that as part of.
We will have it immediately after reopening.
We have also filed an IA lordship. What happened, lordship, there was a stay order in respect of filling up of 42 posts of Mandal in Kasar district lordship. And without vacation of this stay order and without taking leave of this of the honorable court lordship, this 42 posts has been included in the fresh recruitment lordship in the advertisement of 552 posts of Mandal lordship.
What interim order is there?
Interim order is in IA lordship.
No, what is this 28 to 23 order? In this requisition?
The page 23, lordship, IAT.
No, 23.
Lordship,
In IL or page 23.
Lordship, in,
No, this is passed in the writ petition, 28/2/2023.
yes,
28 to
Lordship,
Stay order. What is the stay order?
stay order is,
Impute advertisement is stay.
Advertisement or administration.
Stay. Is
into
that
the
order
advertisement.
vacated?
No, Lordship, but what happened? Earlier, that this advertisement was published by the Deputy Commissioner. As per the new rules, Lordship, Deputy Commissioner is not the appointing authority. Now the director is the appointing authority. As per my lord, that new rules, Lordship, 2023, my lord, that this advertisement has been, my lord, earlier it was stated, it has been cancelled by the Honorable Deputy Commissioner.
Yes, Lordship.
So, but that matter become inspect process because my lord, this order already been, that my lord, advertisement already been withdrawn, Lordship. In our affidavit, Lordship, I kindly see the page, Lordship, 109, Lordship.
109.
Lordship, additional affidavit filed by respondent about
109.
Lordship, Annex 3, Lord.
Lordship, when this repetition is pending, Lordship, and stay order is operating without any, Lordship, with the leave of the honorable court, they cannot, Lordship, cancel the
You can't
advertisement.
cancel it. You have to take leave of the court.
Yes, Lordship.
There is an
And
interim
also-
order.
Lordship,
Also
now,
this-
my lord, the director, my lord, this is the given, my lord, the one-time measure, my lord, for my lord,
That's
whatever.
all right. There is an interim order staying an advertisement. That order remains. It is not
my lord, that
vacated.
advertisement already been, my lord, not in the proceed, Lordship, as because, my lord, this advertisement was in state, my lord, it is gone. My lord, that now, my lord, the director is the appointing authority. Director has
No, the
given, not
question-
only, my lord, including
The
this,
question is that when the petition was filed, there was an advertisement.
there was an advertisement,
Right, wrong, correct, incorrect, there was an advertisement.
Lordship.
There was an interim order staying the advertisement.
Lordship.
Department is aware of that.
Lordship.
Now, during the currency of the stay order, you decide to withdraw that,
Lordship.
which you can't do it because the advertisement is stayed.
Lord, that is state, Lordship. My lord, Lordship, may kindly
Then
see,
how can you withdraw this by this order
Lordship,
at
may
27 May
Lordship, may kindly see the,
without leave of the court?
Lordship rule, Lordship, may kindly see the rule.
This rule
Page
is not
92.
applicable to us, Lord.
So we'll go to the rule later.
Yes.
You are saying that the earlier advertisement is withdrawn, fresh advertisement.
Earlier, it is given by the Deputy Commissioner.
So it is withdrawn.
It was withdrawn.
Withdrawn.
Now,
Now,
my lord, the advertisement is given by the Director of Land Record.
director. Now the question is relating to the same post.
It is not including the, my lord, the only bala for the Kasar disease. It is including all over Assam.
Well,
Yes, it's fine.
It is given, my lord, 552 my lord, post, Lord.
Lordship,
where is that advertisement? Fresh advertisement?
They have annexed in the, my lord, that IL, Lord.
IA.
The page 28, Lordship, may kindly pay.
and also, Lordship, before cancellation of the advertisement, they have included these 42 posts in the press advertisement.
Where is I page number?
28, Lord.
28.
Mm-hmm.
In exercise power of conferred by the Assam.
Now
Then
by
the-
this IA, what do you see?
Lordship, by this, since we were not aware, Lordship, whether these 42 posts were included in this 552 post or not, therefore, we filed this application, Lordship, to
42 posts which were advertised earlier.
earlier 2023.
That they have
Lordship.
withdrawn.
Now, Lordship. Before that, Lordship, they have included this post in the advertisement, press advertisement. And also for Lordship, our prayer is pending, so
You should have amended the writ petition if you were challenging this. Are you challenging this fresh advertisement?
They are challenging by way of this IL, Lord.
we are
Without amending the writ petition.
Lordship, this amendment is not required, Lordship, because there is an stay order operating in this case, and without the leave of this honorable court, they have advertised this post. And also, Lordship, these 42 posts may be segregated from the press advertisement, Lordship. My IA is for segregation of these 42 posts from the press advertisement.
But that
because-
advertisement has to be put to challenge first. Fresh advertisement. You don't challenge it. By way of a writ.
Because Lordship, this advertisement was issued as per the rule 2023. This rule was subsequent to Lordship our appointment as additional mandant, and this rule is not applicable to this petitioner's Lordship.
You are praying for stay and staying the operation and further process of the advertisement 14/3/26. That is your prayer.
There is a pair in the Malad, IL.
BI.
I Lordship. I Lordship pass an order directing the respondents to clarify that the 42 posts of Mandal in Kasa district, which are subject matter of term order dated so and so, are not included in the including advertisement dated 14/3/2026. As per Lordship, they have submitted the instruction that it is included in the 552.
What was the difficulty in seeking an amendment of the writ petition or filing a fresh petition?
Because this repetition Lordship, we have sought absorption of the petitioners in the
Whatever you've
post of
done,
second
in
post
this,
of
in
Mandal.
the present writ petition, there was a challenge made to an advertisement.
Even then,
By way of the IA, you are asking for benefits to be extended to the subsequent advertisement, not on the challenge.
No, we are
even
not
then,
seeking-
Lordship, Malad, they are seeking
we are
Malad
not
absorption.
we are not seeking the benefit of subsequent advertisement.
You see, prayer B and C.
Yes, Lordship, pending such clarification, honorable court may be pleased to stay the operation and further process
How can we stay the operation when it is not under challenge?
insofar as it relates to or may affect the said 42 posts. 42 posts, in respect of which the stay order is operating, Lordship.
Stay order was operating against an advertisement which they say has been withdrawn. Now, the correctness of the actions of the state, whether during the pending currency of the interim order should have been withdrawn, should not have been withdrawn, we'll examine. Now, assuming we say that, all right, they have withdrawn, not proper, but they have withdrawn. Then
Before
the
all-
stay order in respect of the earlier advertisement goes. It is ineffective. So far as the new advertisement is concerned, you are not challenging it. You are not assailing it.
That was not said.
You want the benefit of the earlier interim order govern the new advertisement. How is it possible?
we are not seeking the
That's
the
what
benefit
prayer
of
B says.
fresh advertisement. We are seeking only the Lordship that 42 posts will be segregated from the 552 posts. it is
42 posts reflected where? The fresh advertisement.
No, Lordship. 42 posts in 2023. It was advertised, and this advertisement was Lordship
Is it-
state.
Is it your case that these 42 posts advertised earlier are also included in the new?
Yes, Lordship.
Yes.
Yes.
So therefore you have to challenge that. You're not challenging it.
Lordship, it will be on a separate repetition, but in present repetition, Lordship, the protection may be granted that these 42 posts will not be filled up, Lordship, or recruitment process shall not be initiated in respect of these 42 posts because it is sub judice.
That
Even then, Malad, they
that
are
will do away the necessity of challenging the fresh advertisement. We can give you an interim order extending over the new advertisement, cover the posts which were there in the earlier advertisement. Where is the need to challenge? Must be some challenge. The challenge because the respondents will have to respond to this challenge. You are challenging the correctness of the advertisement. Unless you challenge it, how will they respond? There is no challenge.
even then, Malad, they are in
If you are asking for clarification, we can direct them to get
Yes, yeah,
clarification.
they have clarified that these 42 posts has been included in
Included.
the fresh advertisement.
So therefore, in the fresh advertisement has to be challenged. Here, it is not here. You are bringing it by way of an IA. IA would be to give you benefit or extend the benefit in matter which is sub judice. But there appears to be a fresh advertisement. It's not a originum issued to the earlier advertisement. The fresh advertisement.
This,
You have 1 week to think about it.
this matter will be fixed for, let's say, final disposal.
This matter will fix it for final
And-
disposal. All right. When do you want to fix it for final disposal?
Next week.
Next week, not
Otherwise, if they initiate the recruitment process, let's say, our repetition will be pressed.
we have already indicated you have 1 week
Yes,
to
let's say,
think. So you decide and act accordingly. These matters we'll fix it on 15th of July.
Until that lordship, in respect of 42 post lordship, they will not,
42 posts relatable to which advertisement?
the earlier advertisement.
That is
lordship.
gone.
But lordship, without leave of the honorable.
That
court,
will
lordship,
decide.
Yes.
Until we decide, we can't say that fresh advertisement don't proceed because you've not brought it on record to challenge it to that extent.
15.
Matter we listed for admissions on 15th of July along with the IE. Attempt will be made to dispose of said representative.
Okay.
If you want, you can file it fresh
Yes,
petition. It is up to you. So, Mr. J. Hendick, Mr. Revenue, Mr. C.K.S. Borwa for the state. Please, here.
All right.
Well.
Item 27.
Dismissal from service.
Dismissal.
Lordship will fix it after vacation on a date.
Pleadings exchanged.
Pleading act.
Let us give it for hearing.
Lordship can be disposed of in the admission hearing also.
The pleadings are exchanged in the matter. The records pertaining to the disciplinary proceeding made available for perusal of the court if the needs arises. Matter be listed for admission on a date to be fixed by the legislature.
On 28th July, Lordship.
The month of August. August. Yes. You are challenging, you have changed.
I have
Is there an
challenged the
appeal
order
pending?
of dismissal. Also the appellate. order.
Appellate order.
We have received it.
You have received it.
Lords.
Place it before the court. when the
Can you
matter-
tell 4th, Your Lordship, August, 4th of August?
4th of August. 6th of August. For admission hearing, 6th of August.
Lords. Deeply.
28.
Lordship may kindly peruse this notification.
This is that.
Yes, Lordship. Lordship, this matter.
What are you challenging?
My lord, the matter pertains to advertisement dated page 32, my lord.
32.
Yes, there are
Lordship, if I may. Lordship, this matter should have been listed before court number 10, Lordship. It has been listed by inadvertent.
there are 3 numbers of posts, my lord. I have applied for 3 numbers of posts, but they took 1 interview for all the posts, my lord. That is one aspect. Another aspect is that, my lord, so far as the grade 4 post is concerned, my lord, there is a government instruction not to conduct interview, my lord.
This
Yes.
is relating to High Court and the subordinate courts.
This is, my lord,
Service
Yes.
matters.
presiding officer.
You are already appointed, not appointed.
No, my lord, I am not appointed. Ignoring the government instruction, but they have conducted the interview, my lord.
All right. Mr. B.K. Sharma, the accountant for the petitioner, MS.
P. Sikya, Lordship, on behalf of
Saiki appears on behalf of
Mr. H.K. Das, Lordship.
H.K. Das. MS Saikia submits before the court that in terms of the notification by the order number 3 dated 8th of January 2025, all service matters of staff of Gauhati High Court and subordinate courts and matters pertaining to appointment of staff are to be listed before a specific bench named therein. Registry will accordingly verify and place the matter before the appropriate bench.
Deeply
Just after 2 weeks.
Deeply obliged.
I am led by senior advocate T. Today he is having certain difficulties, my lord. Can it be on 23rd, my lord, Tuesday? It is not inconvenient to you.
No, it has to be after vacation. What is the issue?
We are challenging the compulsory retirement of the petition.
Compulsory retirement. Requires some hearing. Readings are exchanged.
Yes, change.
submitted that meeting the exchange in the matter. Petitioner is assailing the order of the disciplinary authority, rendering imposing compulsory retirement on the petitioner.
Not the disciplinary authority, Lord.
I'm sorry, the appointing authority. The matter be listed again in the month of August,
It will be the end of July.
end of July. August is better. 6th of August. Relevant records, if required,
It is
departmental records, we place before the court for approval.
obliged.
Where is the justice? I think it's possible for the timing. Possible for the timing. Senior counsel takes in another.
My lord, here in this case, I am appearing on behalf of the respondent number 7. My lord, pleading is over. My lord, maybe fix any date for admission hearing or for disposal.
August.
My lord.
The submitted pleading in the matters are complete. Release this matter for admission hearing on 6th of August.
My lord. I appear for 1, 2, 3, 5.
Ms. So and so for petitioner, Mr. A.K. Sikdar for private respondent.
Private respondent.
D. Bora for
1, 2, 3, 5 and
1, 2, 3, 5 and 8. R.K. Talukdar for respondent number 4. C. Soikia for
Petitioner was also recommended by the FLP method. Now, initially he was on forest department, subsequently was the post as an expert in Panchayat and Rural Development Department. His post has also been approved, but appointment has not been. My additional activity is also.
you are recommended by SLC.
Lots.
Where is that recommendation?
At page 31 of our petition.
Nur Muhammad.
Nur Mohammed. The person.
No DLC recommendation.
For a department also, there is no such provision of recommendation by DLC. It was a state post, so
But you are recommended for grade 3.
great. Now also my additional activity, that my additional activity. At
Additional affidavit.
large, page 38.
Yes.
Initially, he was in forest department, since there was no vacancy was there, but subsequently, he was accommodated in Panchayat and Rural Department. So, just I am reading the 11%, which refers to the subject cited above. I am directed to say that the necessary approval has been accorded by the government of Panchayat and Rural Development Department towards appointment of Muhammad Ali, son of Shamsi, on a compulsory appointment under grade 3 post as per recommendation of the state level committee, environmental forest department, Censor. This regards the proposal along with minus of SLC held on Censor are close level for inspecting further investigation from the So it was made on 6th of October 2024. Then Lordship will have the page 40. Page 40 also, again the additional chief secretary has written. It was written to additional chief secretary that with reference to the subject, the government letter numbers on the subject cited above. I have the honor to submit here the proposal for administrative approval for appointment of
What happened after this?
nothing else.
Well, who's for PNRD?
Sure, I will ask to certain instructions.
Hmm.
What happened pursuant to the letter dated 1825.
Hmm.
If you may just please.
What happened?
Lordship, the proposal was returned back to the forest department.
Why?
Because in the SLC minutes, it was not specifically mentioned as to on which department he is to be appointed. And
How
this
does it
is-
matter? There is a decision that is to be appointed in compassionate on the Panchayat and Rural Development, page number 38. Approval is there.
The approval is there.
Lordship may just kindly consider that the tick marks that I. This is the action taken report submitted to the office of the chief secretary, and this is the letter returning back the proposal.
It talks about transport department.
No, this was one of the examples wherein similar. It was a similar case of the petition.
Now, what is the difficulty for returning it back?
They want an approval from the SLC itself that he is to be appointed in the PNID department, because the SLC manuals doesn't speak about which department under what vacancy is to be appointed. It only says that grade 3 post.
But what about the approval at page 38?
Lordship, that was considered, but later on it was again returned back, that proposal.
Where is the personnel department when?
Sure.
Which is referred here?
Lordship, that I couldn't get.
Get it now? Within 1 hour?
Try to get it.
1/6/2015.
Get it? Why on these issues the matters are pending? Under what provision is the secretary returning the proposal of a department who is approved without referring to the approval given by the deputy secretary? Have they recalled this letter, the letter at page 38?
Page 38 there.
This is approved.
In the action taken report, it is there. That is 4th paragraph. Subsequently, while later dated 8/10/24, PNID department forwarded the proposal for appointment of Noor Mohammed, son of so-and-so, to CPRD Assam on compassionate appointment under grade 3 post as per minutes of SLC meeting 2/3/24. However, while later dated 12/3/25, Commissioner PNID Assam sought further administrative approval for enabling appointment of Noor Muhammad Ali under commissioner ground. The next paragraph is one of the cases wherein it is similarly situated. It is relevant to be mentioned that on an earlier occasion, personnel department advised this department to return the proposal for appointment under compassionate ground received from the transport department, citing non-compliance as per personnel department's OM 18/9/24. Transport department had not placed the proposal before SLC.
You show us the OM. Where is that OM?
Not cheap.
After some time, the same.
Yes. This OM is there, personal
Yes,
department.
18/9/24.
After some time, yes.
Not one person.
Right.
My lord, this is a pension matter, my lord. Limited clear in this matter, my lord, the dismissal order of the petitioner has been converted into a compulsory retirement plan. And my prayer is only that I have rendered more than 20 years service, my lord. So it may be as a volunteer retirement. Volunteer retirement.
Voluntary?
Yes, ma'am.
How can it be?
My lord, as per the rule 40 of CCS pension rule.
There has to be an offer made.
My lord,
There has to be an offer made for voluntary retirement.
my lord, I have already submitted the representation, sir.
When?
Kindly see, my lord, annexure 9, my lord. Okay, page number 31 of my petition, my lord. Request for amendment of compulsory retirement to regular service or resumption of volunteer retirement.
When were you compulsorily retired?
My lord, kindly see page number 30, annexure 8, my lord. Paragraph number 3, my lord. In exercise of power conferred on me under the provision of Rule so and so, so and so, so and so, the undersigned hereby commit the punishment of compulsory retirement from service with effect from 2nd May 2020. After that, my lord,
Wait, under what provision are you asking for conversion?
Lord, as per CCS pension rule 40A, my lord.
48A.
A, my lord. A retirement on completion of 20 years qualifying service.
Is an appeal available? Did you file an appeal?
Yes, my lord, I have filed an appeal. After that, my dismissal order has been converted into compulsory retirement.
All right.
And I have rendered more than 22 years service, my lord. 48A1, at any time after the government servant has completed 20 years qualifying service, he may be giving notice of not less than 3 months in writing to the appointing authority, retire from service. That is my simple claim, my lord.
No, this compulsory retirement is pursuant to a disciplinary proceeding.
My lord.
Huh?
My lord.
Then you filed an appeal has converted dismissal into compulsory retirement.
Compulsory
Now, how are you asking it for voluntary retirement?
And I have then, and at the time
You may
of
have, but
onset,
that will amount to interfering with the findings of the inquiry, orders passed by the disciplinary.
my lord. Can be disposed of now, my lord. The direction to
You will dispose of by dismissing it.
My lord, my retirement benefit has not yet granted.
That will direct. That will direct. But
And
your prayer for conversion
compulsory
into
pension has
voluntary
also not been
retirement is
granted.
not acceptable.
My compulsory pension has also been not granted to
That
me
will
till date,
direct.
and retirement benefit, my GPF leave and each and
Everything will
has
be
not been
directed,
granted.
but we can't direct conversion into voluntary retirement.
Right.
That can be done. Heard done a counsel for the parties. Petitioner to this court was compulsorily retired by order dated 9th of September 20. With effect from 2nd May 2020. This order was passed pursuant to the proceedings. The was pursuant to the summary Assam Rifles Court proceedings, wherein the court had sentenced the petitioner to be dismissed from service. In terms of the powers relating under section 133, 150 of the Assam Rifles Act 2006, read with para 264B, the Assam Rifles Regulations 2016. The punishment of dismissal from service was commuted to compulsory retirement from service with effect from 2nd of May 2020. So, petitioner thereafter filed representations before the authorities requesting for converting the punishment of compulsory retirement to that of voluntary retirement. So, the respondents have contested the matter by filing their affidavit, disputing the contention raised by the writ petitioner. Stop. Stated in their affidavit that proper proceedings as contemplated under the Assam Rifles Act, read with the rules, the regulations have been followed, and the initial punishment of dismissal from service imposed by the summary court of the Assam Rifles or summary Assam Rifles court was converted to that of compulsory retirement so as to grant the retirement benefit and pension to the petitioner. Stop. Therefore, after the order has been passed, and did you file any appeal against the conversion order?
Is the conversion order I have not filed appeal, only representation I have filed.
No appeal has been filed, and representations have been made, which, however, stood rejected. So, that I having heard counsel for the parties and upon the proposal of the petition, you see that pursuant to the proceedings initiated by the Assam Rifles, summary Assam Rifles court, imposition of punishment of compulsory of dismissal from service was imposed. Stop. Disciplinary authority thereafter converted this punishment into compulsory retirement so as to enable that petitioner to receive his pension and other retirement benefits. Stop. Counsel for the petitioner is referred to Rule 48.1 of the CCS pension rules to submit that one capital A, that a request may be made to the authorities to, you're referring to 1A.
I know. 48(1), my lord.
Huh?
48(a)(1).
48A1.
My lord.
48 capital E1 to submit that the government servant who has completed 20 years of qualifying service may, by giving a notification, notice of not less than 3 months in writing, may retire from service. So, the result of the provisions reflect that this option would have been available to the petitioner prior to initiation of the proceedings under the summary Assam Rifles Court and the imposition of punishment is stopped. Once the punishment is imposed by the procedure prescribed and that punishment stood modified or commuted to compulsory retirement by converting it to compulsory retirement so as to enable petitioner to receive his pension benefits, the prayer of the petitioner to file an application under Rule 48 capital E, the CCS rules cannot be permitted. Stop. The scope of the petitioner making application under 48E is not available after proceedings are initiated by the procedure prescribed by the appointing authority under the Assam Rifles Act rules, regulations, and punishments are imposed. So, no appeal against the punishment imposed has been filed by the petitioner. Therefore, the order of dismissal, which to convert it to compulsory retirement, has attained finality. Therefore, the claims made in the petition cannot be allowed. Stop being devoid of merit. The same stands dismissed, notwithstanding the order of dismissal passed. If any claims the use of the petition, financial and monetary claims and dues, the writ petitioner is required to be paid by the respondent authority. The same shall be released without further delay after due verification within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition closed in terms of the above.
And so, Lordship, the petitioner may be directed to furnish the petition pension copy. Your Lordship.
Whatever you want, you direct him after furnishing of the certified copy. Writ petition closed in terms of the above. Your Lordship.
Giving related money. Admission having negative.
What is your matter?
Matter my termination my
Termination.
service. That's my
Appeal? No appeal file.
One representation was filed, but that representation was treated as a matter appeal. The appeal was dismissed.
Dismissed.
In our affidavit, we already been annexed, Lordship. Page
My
90.
lord, please see the page 55 termination order. No reason, nothing has been mentioned.
The termination order, nothing will be mentioned. Where is the inquiry report?
No inquiry, my
My
lord.
lord, it is a contextual employee.
It is a contractual employee as per terms.
Terms and
Terms
conditions,
and
my lord, if, my
reference,
lord,
my lord.
in the past, my lord, the percentage of the, my lord, the performance, performance was not good, Lord, that's why, my lord.
So there has to be some finding
Lordship.
by the authority.
No, as per terms and reference, my lord, at page 36, my lord. My lord, can you hear? Page 40, my lord. Can you see page 40?
40.
40.
Yes.
The annual performance appraisal, my lord. As per annual performance appraisal, my lord, petitioner recommended for A plus grading. That is the 90% above. But he terminated and can you see 41? Notification, my lord, has been issued. Committee has been constituted for, my lord, evaluation of the assessment. And as per terms and reference, my lord, this committee, my lord, would not be terminate the petition of my lord because the terms and reference clearly stated that the annual performance has to be considered.
No, where is the performance? What is that?
Page 47, my lord.
47.
Okay. My lord, in the Borpeta district, CL number 5.
And my lord, surprisingly,
But my heart, my lord, the percentage was 59.
my lord,
Borpeta district.
Lordship, now kindly see the serial number 5, Lordship.
5.
Algesia.
Kalgosia.
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 Itumone Odekari, the 59.
And surprisingly, my lord, out of 143 candidates, my lord, only she got, my lord, one lesser mark.
Why is the performance is lesser?
My lord, and as per their
How is the performance assessed?
Lordship, my lord, that
So, my lord, this notification and this process has not been continued, my lord. Only for that year, my lord, it was made.
How is the performance assessed?
Lordship, my lord, that 31 lordships. Kindly see the
Page 31.
31. The great increment table. Great overall percentage lordship. A grade plus is my lord, a 90. This is the my lord, the percentage wise, my lord, that
No, how is the assessment vis-a-vis the other candidates?
38
Assessment.
lordships. Page 38.
38. 38.
Annual performance. That's right.
Well, performance was A plus, my lord.
Everything is good.
Lordship. And page 52 lordship. Then the evaluation officer lordship, my lord, they have examined the
52 is a representation.
42.
42.
Schedule performance evaluation of the field officer of the 35 district lords. Just my lord, that the committee has been, my lord, constituted to evaluate the, my lord, the performance lords.
My lord, can we see 54, man? The circle officer was not forwarded the, my lord, can we see page 54? District Commissioner, Kolkata. Sent by circle officer to Gauhati. Forwarding of application submitted by Gitumani Adhikari, field officer, disaster management, Kolkata Revenue Circle, my lord. Now, last paragraph, my lord, can we see? Further, I would like to request your esteem to kind consideration of the matter, her termination from her service for this time only on humanitarian ground, if possible, else.
Circle officer has given a positive report.
My lord, it was given to the positive, my lord, as per my lord, that committee, my lord, they can, my lord, only, my lord, given the performance report.
And
The
that
committee has been
committee-
constituted.
Committee will have to find a manner in how the assessment is to be done.
And my lord, can we
My lord, that's
see?
why, my lord, it is, my lord, constituted that evaluation.
Huh?
The
Huh?
committee has been constituted only because of that, my lord, to examine the.
Only for that year only, my lord. That
So
committee has
we
not
want to know
continued
the,
further.
what are the criteria, what is the criteria on the basis of which the committee has evaluated? The circle officer has given a good report. The page number 38, if you come, 39, you find this is to be filled up by the district project officer. These are all good, obedient, regular. There is no adverse remark. Then how the committee is given this?
That instruction, that is because, my lord, that the
My
respondent
lord,
number.
can we see their affidavit, my lord, page 93, my lord. That committee, my lord, comprising of, my lord, district comprising of district commissioner,
Paragraph, page number? Page number?
page, that committee, my lord, that page 41, my lord. Committee at page 41. And they are affidavit. At page 93, my lord.
You get the records of the petitioner regarding the
Can we
performance
see?
evaluation.
EC, my lord,
Page
EC awarded page 93, my lord.
93.
93, they are affidavit, my lord. EC awarded 70 marks.
C awarded 70 marks.
70 marks. CEO disaster management 54 marks. And circle officer 50 marks. As per our information, my lord, circle officer, my lord, who recommended the petitioner, my lord,
Gave the lowest.
is the lowest. And my lord,
Same circle officer.
same circle, same circle.
It is out of 100.
Out of 100.
Lordship, out of
And what is the benchmark required? More than 60.
more than 60, Lord. The higher, my lord, that aggregate is a 58.8.
Is the circle officer Eric is a party?
Lordship, by name,
Yes,
By name, who is appearing? For the circle officer? Notice served.
Notice served. As per rule 11, not
Notice served or
notice served. Their affidavit, my lord, they say the committee comprising of 3 persons, but in the score sheet is, my lord, shows the five person, my lord.
Five percent. 5%.
We remand it for re-evaluation. Yes? Circle officer has not appeared.
Why not?
Will you take dusty service?
No, we have time.
The postal record shows that it was delivered, but there is no AD card received. So who is for respondent 13?
39.
You are there. Who's 13?
13 is one of the members of that evaluation.
So your grievance is against
Against the
respondent 11.
11.
11.
I call for the score sheet, original score sheet, man. It will be available.
Heard Mr. A.J. Atiyah, and counsel for the petitioner, Mr. A. Hendick, then counsel revenue for respondent number
1, 2, and 3.
2 and 3. Who's for 3? For 4,
6, 7, and
Mr. P. Sogia for 4, 5, 6, 7, and 8. And Mr. A. Bhattacharya for respondent number 13. So this note reflects that service in respect of the respondents 10, 11, 12 have been complete. However, none represents the same when the matters are called. Petitioner is relieved by the order of termination. The petitioner was rendering service as what?
Field
Field
officer.
officer.
Field officer
Field officer.
on contractual
In the
basis
Office of District Disaster Management
of the Office of the District Disaster Management Authority,
Authority,
Borpeta,
Borpeta.
Borpeta.
Place of posting
Her
at
place of
Kolgatia.
posting is in Kolgatia under the Borpeta district. So petitioner was terminated on the basis of the evaluation report given by the committee constituted. Where is the committee?
Go to NXRC page 79 in our epidemic. Oh, sorry, in our epidemic. Page 79.
Committee constituted by notification dated 9/5/2024, comprising of the following officers. Come to the 79. Stop. From the evaluation report, which is enclosed in the affidavit filed by the respondents, and which is a part of the order dated 29/4/25. So far as Borpeta is concerned, Revenue Circle Kolgatia, Borpeta is concerned, the marks given by the officers of the committee are as under extract code 39. First table. The candidate is required to obtain more than 60% marks, below which the services are terminated. So petitioner obtained 58.8. It was accordingly terminated. So from the pleadings available on record,
Annual performance.
the communication of the circle officer dated 4/10/2024 addressed to the district commissioner Borpeta is available, where the performance of the petitioner was found to be satisfactory and no untoward situation has been faced during her tenure. Stop. It was stated that her presentation was good, and rather the commissioner, the circle officer, found the marks and the grade surprisingly. I was surprised to see the marks and the grades allotted to the petitioner, as in the opinion of the circle officer, she did not deserve that grade or marks as a performance. So, be it as it may, since the pleadings are complete, the respondents will place before the court the evaluation records, the records pertaining to the evaluation of the writ petitioner and other candidates available with whom?
My lord, maybe the district commissioner, DDM. DDM.
Respondent 4.
Lordship.
CEO,
Respondent
DDM.
4.
Chief Executive
Insofar as
Officer.
Borpeta is concerned, and the revenue circle of Kolgatia, case before the court of state of the state. Release this matter on 31st July.
Went to the Malad respond about 2 and 4.
Hmm?
2 and 4.
2 and 4. Okay,
Update
2 and
by one. But
31st.
30. 29th. 29 July. 29. 29 July.
Yeah, then 31.
notification I have given. Notification I have given.
Where is
Clause
the one?
clause 15 of the signature.
Notification of
15.
15 notification.
Clause 15.
Ah.
Clause 15. That's it. At 10 and page 6.
Ah.
Yes, I'm reading. Sufficient vacancies are not available in any particular office to accommodate the persons with a working list for completion appointment is open to the administrative department office to take up the matters with other department officers of the government to provide an early appointment on completion ground those in the waiting list. On the basis of this,
Also the forest here, forest. Forest department has given some approval. Where is that sanction? Where is that approval by the SLC?
page 31,
31.
minus of the essence.
Minutes of the SLC.
Last part is
Yes, Mr. Bothago.
Yes, my lord, this recommendation is there, and
The recommendation is there for grade 3, but where?
in the table itself, my lord will find that person has recommend no DLC recommendation available as matter relates prior to 2000 due to shortfall in vacation.
No, recommended for the post, grade 3.
Grade 3.
Which department?
To PNRD
So
department.
where is, have you stated all that?
My lord, that instruction was produced by my learned colleague, my lord, from the other side. That otherwise formally we did not receive that communication. That PNRD is it was forwarded to PNRD.
His father was your employee.
Yes.
Under the forest department, there is no such thing as a DLC. So SLC. You recommend his case. Now, going by this, page 31, it appears that you have recommended him for a grade 3 under the forest department.
Yes.
Where is the recommendation that it was taken up? There is no vacancy. It was taken up with other departments. PNRD has.
The petitioner has filed an additional affidavit, my lord.
He has filed. We are asking from the minutes. Pursuant to the minutes, what happened?
pursuant to the minor procedure as per my instruction lawsuit, since there were no vacancies for a department. So accordingly, lawsuit, they have communicated the thing to the other lawsuit of principal secretary. And principal secretary lawsuit sought for information on whether there is any vacancy in any department. Accordingly, lawsuit in the panchayat and rural department, some vacancy was found. So this there was some communication.
So all these communications, where
Yes,
is it?
communication are not with me lawsuit. I have got only.
So opposite is not with
There
you,
is
but
some communication also, but I'm sure communication made produced by direct train also. There is some written communication also. And once it is also approved, after following all the procedures, now how can we take my claim?
But there is some development as of late of, my lord, the PNRD has returned the proposal. PNRD says
No, that we have seen, therefore we had wanted to see the reference which is made in this proposal which is returned. That
My lord, these will require some fresh instructions, my lord, because
why these crucial instructions are not available in spite of the repeated opportunities being granted. There is no dispute that SLC in the forest
but you know what
has
is
recommended.
25.
Where is the direction of the High Court earlier?
Lords. At page lordship, represented page 28
Page
of my report.
28.
Last paragraph. In view of the above joint submission made by Mr. Kolita and Mr. Gauhati, this litigation stand closed without going the merit of the claim of the petitioner, with the observation that the decisions to be taken by the state level committee in respect of the applications of the petitioners for petition.
What did you challenge here in the writ petition?
Lordship, here in this petition, Lordship, first petition, I have challenged, Lordship, my name was not placed in the neither in DLC nor in SLC, Lordship. So we submitted representation that was not considered, so we have to. So during pendency, the reparation also some instruction came from the department side, and my friend was also there, and he has also placed the instruction that by mistake was by or inadvertently his name was not placed before the SLC, so they will consider my case FS. Accordingly, also my name was placed FS in the next SLC, and next SLC recommended my name.
Yes.
My lords, I found some communications from the PNRD department. They have returned the proposal on the views endorsed by the personal department, advice of the personal department.
Where is the person? Where is the order by which communication by which it was returned back?
Lordship, I have furnished it along with the action taken.
That was it.
So there is an OM dated 18/9. Where is that 18/9? Mr. Polita, you have submitted this 1st of June 15.
Lordship,
This is not required. 18/9.
Lordship will have the
18/9. Yes.
Lordship will have page Lordship 31. My recommendation was on the basis of this notification. Yes, there is specific mention also of this notification 16715.
No. So 18/9. What is 18/9?
18/9 it is of 24 also.
That is what is reflected here. 18/9/24.
24. That notification will not come to this case because my case was prior to that also.
Nine, my lord, that taking cue from Devabrata Tiwari, my lord, that
That will not affect my case also.
robot what is it? तो अपने कितने रुपए? एक कोट पे उनको क्या? 9 minutes perhaps has no relevance here.
Our counsel for parties, this petition is filed with the petition seeking a direction to the court for appointment to the post of, for appointment on compassionate ground in terms of the recommendation, the SLC, favor of the petitioner in his meeting on 3/20. Brief facts necessary beside this matter are that the petitioner's father was serving as what?
Forest guard.
Forest guard, the forest department. Died in harness on 6/10/2021. So 2001. So the petitioner submitted his application for consideration of his case for appointment on compassionate ground. He submitted that the petitioner is physically handicapped person having 45% locomotor disability. He's no longer 45%.
No, sir. But he was 45.
Was earlier suffering from some locomotor disability, but I think undergone a major surgery. Disability is sufficient extent. So the claims of the writ petitioner not being considered, the petitioner approached this court by filing WPC number
Resolution number 2697 of 2020.
2697 of 2020, which came to be disposed of by the following order dated 4/11/2022. Please number. So, where in deference to the said order, the matter was placed before the SLC, the Forest Department. So, it's given to understand by the Council for the Forest that in respect of appointments on compassionate ground, so far as the Forest Department is concerned, district level committee, the matters are placed for the SLC. And the SLC, by its minute, dated 2/3/20, recommended petitioner to be appointed in a grade 3. So, pursuant to this recommendation, Deputy Secretary to the Panchayat and Rural Development accorded permission for appointment of the writ petitioner in a grade 3 post under the PNRD department. So, the commissioner in turn sought approval from the additional chief secretary, Government of Assam, PNRD, for appointment. Sought for administrative approval, so as to enable the commissioner to appoint the petitioner on compassionate ground under grade. So, pursuant to the issuing of notice, meetings have been exchanged. Sorry, respondents have not filed any affidavit. Pursuant to notice of on opportunities being granted to the respondent, PNRD, today when the matter is called up, the Learned Standing Council has placed before the court the communication dated 28/7/2025. So, by the said communication, matter was returned back to the Environment and Forest Department. They request to place the matter before SLC to obtain approval for appointment under PNRD in due course of time. Stop. Say communication, a reference is made to the OM dated 18/9/2024. In the absence of any counter affidavit being filed, the submissions made by the respective counsel to the respondents are considered. So, the petitioner submitted his application for compassionate appointment in respect of the services which were rendered by his late father for due appointment, as his father was stated to be the sole breadwinner and who expired on so and so date. So, his application came to be placed before the SLC. The SLC, by the minutes held on so and so, recommended appointment in grade 3. So, the said minutes do not reflect whether the appointment is to be made under the Forest Department or under any other department. So, from the communications brought on record by the writ petitioner by way of additional affidavit, it is seen that communications were issued between the forest and the PNRD, and the PNRD department had accepted the proposal, had sought for administrative approval for appointment of the writ petitioner in a grade 3 post pursuant to the recommendations granted. So, this makes it clear that there was some parley between the petitioner, between the Forest and Environment and the PNRD for appointment of the petitioner in grade 3. Stop. There is nothing on record to suggest that there are no vacancies available under the Forest Department. Be it as it may, from the communications exchange between the PNRD and the Forest Department brought on record by way of an additional affidavit by the writ petitioner, it is apparent that the PNRD department has taken steps to request for administrative approval or appointment of the writ petition. Stop. However, by the communication dated 28/7/2025, it appears that the proposal has been remanded back to the Forest Department for being placed before the SLC to obtain approval under the PNRD department in due course of time. Stop. A reference in this regard was made to the communication OM dated 18/9/2024. Stop. There are the 18/9/2024 OM was issued by the state for reviewing of the schemes for appointment of a family member of the government servant on compassionate appointment, referring to the judgment of the apex court rendered in state of West Bengal versus Devobrata Tiwari, civil appeal number so and so. The following decision was taken by the state to this particular notification, the apparent as poem has been issued on 18 September 2024, and there is no reference in the OM that it will have any retrospective effect. No. Case of the petitioner was considered terms of the directions issued by the court by the order dated 4/11/2022 passed in WPC 2697 of 2020. So, therefore, at the time when the direction of the court was issued, this OM was not enforced. So, prior to the OM dated 18, the SLC minutes recommending the petitioner for appointment under grade 3 was also taken on 2/3/2023, well prior to the issuance of the OM dated 18 September 2024. So, prior to the issuance of the OM dated 18/9/2024, the OM dated 1/6/2015 was in force. By the subsequent OM dated 18/9/2024, it is also not stated that the earlier OM dated 1/6/2015 has been superseded. Earlier OM is superseded.
Circulated by 2017.
Okay.
1/4/2017.
Where is that?
That was regarding family pension in lieu of compensation. That- That is punishment.
Huh?
17. By saying that no more compensation.
That was in 17.
That was the 7. 1/7.
Where is that notification?
Regarding your compensation appointment regarding family pension.
14/7, 14/9/24. Huh? The state OM dated 1/6/2015 came to be superseded by the 14th September 2017. So, what will be the effect of this 2017 notification?
That will not improve, but my case, I have approached this for after issuing that notification. So as issued 17 losses, I have approached this for in 2020.
Huh?
So losses.
You are referring to 2015 notification?
Yes, 2017 notification only was, since compensation appointment has been closed by the department, there is a notification that instead of compensation appointment, government will provide full pension to the, that much is there in that
Ah.
notification. So what's in my case is
So
not.
you are entitled to compassionate family pension.
No,
Why?
I'm not entitled. Because after the merger of 2017,
Huh?
not prior to that. If subsequent to passing this notification, someone dies, their family will get the family pension. Not lordship demise prior to 17. That is clear, lordship. After 1/4/2017, if someone dies, they have no right to claim compensation appointment. They will get full family pension. And if someone dies prior to
You
that,
show us from the notification that this is the.
this is not notification, not with me, lordship, but that is the lordship.
No, it is before us. We have a copy.
Yes.
Give it to it. Show us where it is there.
And my case was lordship. There was a direction from the Honorable Court after passing this notification.
That notification was not considered by the court.
Lordship, no, still lordship compensation appointment is going on, lordship.
Although Lordship, even after developer theory's judgment and notification of 14/9/2024, still that is going on. Lordship.
However, even when results to the completion development will be applicable, right on or before 31
Okay.
is correct.
By the said OM, the earlier OM dated so and so superseded. However, at clause 5.11, the said OM dated 2017 is provided as under 5.11 to extraction. Coming to the facts of the case, the petitioner's father expired on 2001.
Lordship.
Therefore, since his father expired well prior to 31/3/2017, the notification of 14/9/2017 is not applicable. So far as the provisions of 1/6/2015 is concerned, at clause 15 of the said notification, it was provided that if sufficient vacancies are not available in any particular office to accommodate persons in the waiting list for compassionate appointment, it is open to the administrative department or office to take up the matter with the other departments or office for the government to provide an early appointment on compassionate grounds to those in the waiting list. So, that being the provision, from the communications exchange between Forest Department and the PNRD, it is apparent that PNRD had accepted, had forwarded, had taken steps to obtain administrative approval from the concerned departments. So, under such circumstances, it's clear that there is a decision in favor of the writ petitioner taken by the SLC for appointment in the post of grade 3. And the PNRD department has also taken approval, has taken steps to seek approval for seeking administrative approval for appointment in the grade 3 post under the PNRD department. So, the notification placed before the court by the Standing Council PNRD, communication dated 28/7/2025, placed before the court by the PNRD, Standing Council PNRD, requiring the proposal to be returned to the Environment and Forest Department for being reconsidered by the SLC to obtain approval for appointment under PNR appears to be not in conformity with the notifications and the circulars of the government of Assam. So, under such circumstances, name of the writ petitioner has to be allowed. The PNRD department will now take steps to obtain the required administrative approval for appointment of the writ petitioner in the post, as per the decision taken by the SLC by the minutes of the meeting held on so and so. Petition accordingly stands closed, disposed of. Let this exercise be completed within a period of 60 days from the date of receipt of a certified copy of this. Disposed of.
Degree of language.
Period of maybe extended 90 days.
Do it under 60 days. Why 90 days? Already the matter is delayed. 24 matter.
But everything was going fine. Personal advice has done, man. Department of Personnel, that minutes.
So personnel is not understood or probably read with corrections.
The declarations of the arbitrators were supposed to come. I had checked up the record. The arbitrator that we had suggested and in fact the lordship had appointed, the declaration is yet to come. I have also inquired because it was sent by speed post. Probably it has not reached. May I seek for some more time so that you may respond to it?
Yes.
27/5 by speed post, it was sent from the registry.
We can't advise you, but
Therefore, I'm seeking another 2 weeks time of accommodation.
yes,
Let it come up on after reopening.
in deference to the earlier order dated 14/5/2026, learned arbitrator were appointed by the court. Justice D. Biswas, former judge of the Gauhati High Court, former acting chief justice of the Gauhati, and Justice Siddharth Medu, former chief justice of Manipur High Court. Stop. The learned arbitrators were required to furnish the written declarations under section 12(1) of the Arbitration and Conciliation Act. Copies of the order was required to be communicated by the registry, but it was also granted to parties to submit a copy thereof. Stop. Justice D. Videndra Biswas, former judge of the Gauhati High Court, former acting chief justice of the Gauhati High Court, by communication dated 6/2026, has forwarded a written declaration expressing no difficulty or handicap in acting as an arbitrator in appointed stop. However, the declaration from Justice Siddharth Medu, former chief justice of the Manipur High Court, has not been received as on date. The learned counsel for the respondent submits that the matter will be called up immediately after the opening. Accordingly, as agreed to by the parties, released on
20 July 20.
20 is a Saturday, sorry,
Monday.
Monday. 20.
Monday.
Obliged.
This case is completely. Madam, it's not hearing.
After vacations, record me also.
This is what dismissal matter. What?
Selection.
Selection of what?
Physiotherapist.
You stated file affidavit where we are
The parties have exchanged the pleadings, submitted that the matter is right for hearing, ready for hearing. Accordingly, this matter in the month of August.
Date
In the part 2 hearing list.
These are daily.
Huh?
The part
Should call for the reports. List in the month of August. Some date.
published.
Okay.
Lordship, DP has been concluded, Lordship.
Huh?
DP is open, Lordship.
What is open?
Departmental inquiry, Lordship. It is complete, Lordship.
Complete.
And the inquiry report has been furnished to the petitioner, Lordship. She also has filed her reply to the inquiry, Lordship. And the final punishment order is awaited, Lordship. Whatever the final
Your
order is.
Lordship, may I please? Your Lordship, my senior was present before this honorable court. However, during the break time, he received the emergency call as his mother fell from the staircases and he had to rush back in order to get her admitted in the hospital. Therefore, I prayed for a short date after vacation.
It is submitted, an adjournment is sought for on behalf of the council, arguing council, petitioner. It's submitted, the petitioner is had some medical. M. Bhattacharya, additional senior government advocate, here for the respondent. Released his matter again the month of August.
Deeply obliged, Lordship.
Things are complete, They want to file a reply here. We have
It
filed
is
a,
not complete, my lord. I have to file an,
we have filed a reply.
I have to file an affidavit. Finance department is not filed. We have not filed.
What is your grievance?
My lord, my grievance is that we are directly, my lord, a supervisor under social welfare department. Our whole grievance that there are about 986 sanction posts of supervisor and 12 statistical assistant. Out of this 400 posts of supervisor, my lord, they were regularized. But we were not regularized. And similarly situated, we were also contractual employees. Now what the government has done, government, my lord, has put us on a regular pay scale, but they have not regularized. They said that your salary will be under 0-2 wages head, not 0-1 wages head. So our case is, how can you treat us differently? We are the same class appointed together like a contractual employee. So one section of the employees you make them permanent regularized, and you have not regularized our service. There is a cabinet decision which has been taken, and we have challenged that cabinet decision. If your lordship looks into the decision of the cabinet, at page 269. 269.
69.
Yes. If your lordship troubling your lordship first with 165, please see 165 for a moment.
165.
Yes, then I will show it.
Yes.
This is 29th of May 2019. Creation of post in respect of 986 number of supervisor, 12 number sales assistant. With reference to the subject, I am ready to convene a sanction of Governor Assam for creation of post in respect of 986 number of supervisor and 12 number of statistical assistant under in the Director of Social Welfare Assam in the scale pay. Expenditure is so and so under 01. Kindly see my lord. 01 salary is so and so. The corresponding state share 10% head of account so and so, so and so. This is the approval of finance. So all these 986 number of supervisor and 12 number of statistical assistant, out we also fall under that out of 986. Now they said all these 90% shares central government, 10% is state, it will be under 01 head. Now please see now the at 265. Please see the 269 minus. $269. Now what they have done, after thread-based discussion, Council of Ministers instead of regularization approved grant of regular pay scale along with other benefits as admissible to government servants, to contractor, supervisor and statistical assistant. Now they said that we are giving you the regular pay scale, but we can't regularize your service. This is our grievance, my lord. Now if you see, yes, 228, kindly see. Please see 228. 228, please see 228, man. Now what they have done, in pursuance to that cabinet decision, they issued a notification 22nd of February. My lord will kindly see, in pursuance of government approval, 587 number of contractual supervisor and 9 contractual sales are shown at so and so, allowed to draw amount equivalent to regular pay scale along with other benefit as admissible government servant out of head of account 02 wages. So now, my lord, how they can, my lord, deviate from 2019 at page 165? Please see 165. How can they deviate and they say 02 wages? Please see 165, my lord. It'll be easier to connect. See 29th of May.
Yes.
Of 2019. Kindly see. Creation of post respect of 986 number of supervisor, 12 number of statistical assistant, my lord. Now 400 already it has been given. 400 post of supervisor that has been regularized. 400 post.
You are claiming essentially for regularization.
I can claiming for regularization. If you have regularized those 400 at pace to 165, why my services not be regularized? This is our case. You cannot create a class within a class. That's our case.
Yes.
This brief was being handled by Mr. Ardner. He is on legs in court number 2. Lordship may fix it immediately after vacations. Let them file a reply. Let the matter be heard finally.
Who will file a reply?
If the petitioners want to file
You
a
have to
reply.
file a reply.
I file a
If they
reply.
want to file a reply.
But this is
Otherwise, your
The
lordship,
pleadings are complete otherwise.
from our side, we have filed an affidavit.
my lord, finance has to
Finance?
file.
Yes.
Why have you not filed?
Yes, lordship, here. Our instructions are updated, lordship, here, we perhaps.
Awaited.
So, lordship, yes, some time may be granted so that at least we can bring on record our.
If you agree to the proposal of the petitioner, we can close it.
No, lordship, we are not in agreement, lordship.
You're not.
Yeah, there is some distinction, lordship. I just need to complete our instructions regarding the disparity.
You have taken time 18/3/2026, 29/4/2026.
Lordship, yes.
Now today is my lord. Some employees will retire also.
Yes.
Yes, after one short date, immediately after the vacation, within that, we'll file a affidavit. One chance maybe granted.
We'll record your submission.
Yes, lordship,
And if you fail, then we'll impose cost.
No, lordship, lordship, if instructions are not there, lordship may proceed the materials available on record.
All right. Third, Mr. D. Das, Senior Counsel, assisted by Mr. R. Islam. And also Mr. B. Bora for
Respond numbers 1, 2, 3, and 4.
1, 3, and 4. Mr. H. Alia for
Finance department. Respondent number
respondent 5.
5.
MS R. Dev for Mr. S. S. Roy. For respondents 6 and 7. 7 also. 6 and 7. The state respondents have filed their affidavit. However, the finance department, counsel to the finance department, reviewed prayer for other time. Union has also filed. No.
Okay.
The Union of India has also not filed their affidavit. Let the pleadings be completed and the matter be listed again on 7th of August,
Lordship.
by which time the pleadings be exchanged. In the event the affidavits are not filed by the next date as permitted, court may proceed to hear the matter on the pleadings.
Yeah, Lord, this is the recovery from pension, my lord. Lord, an amount of rupees 4,19,725 sought to be recovered, my lord. The Annexure 7, my lord, page 25. They finalize the pension, my lord, with the recovery, my lord. Page 25, my lord. Yes.
25.
Yes.
What is there?
This is the pension payment order, my lord. Here, my lord, in middle portion, my lord.
Recovered.
Recovered 4,19,725
For what purpose?
is to be recovered from the area and future rent.
For what purpose?
My lord, this is excess royal, my lord, excess salary, my lord, due to wrong fixation of the salary, my lord. My lord, please see, my lord. Annexure 3, my lord.
Yes. Who's for the respondents? What do you say? What is your stand here?
We have filed affidavit in this regard, matter. But sir, he has been wrongly fixed, my lord.
Huh?
Sir, he has been wrongly fixed at the time of postponement. And we have filed affidavit.
Amount has been recovered.
Yes.
No, my lord,
Not recovered.
Not that extra 9 instruction PPO has been issued, and about we have Petitioner filed another case. Hearing case number.
That
very
was
not-
closed.
not addressed.
That was against the proposed recovery. Thereafter, this final order is passed, my lord, at page 25.
So now the amount.
Yes.
Pension disbursed
Pension
Pension
disbursed,
disbursed.
my lord.
Pension disbursed and.
minus the, after deductions.
Yes.
Not yet recovered.
Treasury.
No, they will not recovery, they will deduct it from your amount. Adjust it, with the pension.
Adjust, they will adjust, my lord, but not yet adjusted. It will adjust against the arrear and future relief, my lord. So, DCRG already paid, my lord, only pension is now. In the meantime, my lord, this pensioner also died, my lord. And now the wife and two children are there, my lord. Their wife is,
Have you substituted?
yes, my lord.
Where is that order?
My lord, my lord. The order passed in IA 1737.
We are disclosing this petition because there is no, what about the irrigation department? What department?
Here we have written to the Treasury Officer Mongoldoy to requesting them to recover amount of this 4,90,000. And now the
Which is
Treasury.
the administrative department?
Irrigation.
Irrigation. Have you filed any affidavit here?
Yes.
What have you stated here?
The amount of this method is
And
done by
who is responsible for that? Who's responsible for the? Where is the order for recovery? Any order passed?
No separate order. is there.
The AG is not the authority to direct recovery. There has to be an order passed by the administrative department. Where is that order?
Index 6, my lord, page 24.
Hmm?
Index 6, page 24.
NHR 6, page
24.
24. This is for forwarding the full recovery statement.
There is no order.
Let's say while forwarding the pension paper, department also forward the statement showing the excess rate. On the basis of that, we have proceeded.
There is no order.
Thereafter, TPO.
Page number 19, what is page number 19?
19 is the calculation.
What else is it? What order do you want? This is the order for recovery.
My lord, submit the pension papers of so and so. Reference cited, I have done not to resubmit the pension paper in paper so and so after meeting the Accountant General's observation for the necessary action, the government dues will remain outstanding due retirement of the government servant, which need to be recovered out of the amount indicated below. The amount may kindly be recovered from his pension. Lord,
Here, petitioner has said that recovery has not been made only, and he is getting his pension. So, what is how the petitioner is agreeing at the moment is lordship. So, there is no recovery, and he is getting his pension. Then,
page 25 in the my lord order, my lord, they have passed.
yes, the recovery is acceptable or not, that lordship will decide. Whether
Is it recovered now?
Not recovered, my lord.
recovery has not been made. Whether recovery,
See, my order stated that amount so and so is to be recovered from arrear and future relief. Should be recovered, my lord, future relief from future.
the lordship may take an observation for the state that no recovery is to be made in the next date, and lordship may decide on the next date.
Already there is an interim order, my lord, not to.
There is an interim order.
Yes.
Yes.
Therefore, no recovery.
My lord,
And prior to issuing of interim order, Your Lordship, we have already issued PPO. Interim is, the interim order passed on 4/8/25, and we have issued PPO on 10/7/25.
Now you have.
Now, we
you
have
to
written to the
issue-
Treasury officer to
Issue a
recover.
fresh PPO. In the, what is this?
family pension.
Family pension, FPPO will have to be issued now. The government officer has expired already.
Yes.
What steps have you taken there?
My instruction, my lord, family pension. My instruction, my lord, family pension is already.
Your instructions, you have to bring it on record. What you have received, what you have not received. Where have you stated all that? Then petitioner will file additional affidavit to bring on record the status of the pension/family pension and other deals received or receivable by the petitioner as a legal year. Released when? In the month of August. Interim order, when he passed earlier, will continue. MLD Neo for litigation and Mr. R. Boro for accountant general.
7.
Mr. A. Chalia for finance. Mr. D. Bora for respondent 4.
So the date may be.
You bring it first on the affidavit.
All right.
This matter, my lord, we are filing an affidavit on Monday. That is not on record.
Right. You received copies, Mr. Das.
I have received. I think I have to give a reply also. Because at page 80 and 81,
Is
we are
not-
saying something else now.
I think we have a copy here.
Yes.
Yes, it is there.
It is there, my lord.
Affidavit dated 11 March.
No, my lord. Day before yesterday, Monday. 16/6.
Filed by whom?
Filed by my lord, PWD, my lord, Pradeep Kumar Nath. Deputy Secretary, my lord. No, my lord, this is a new affidavit. That is by earlier by Sanjeev Sam, the chief engineer.
Because parent, they said that a parent department has to give an instruction. So has to file. So now they have filed.
So that Mr. D. Das, the council assisted by Mr.
I.
I, may I please. Petitioner, Mr. R. Hall, learned standing counsel. Here's for the department. Submitted by Mr. Hall that affidavit has been filed
16/6.
by the Deputy Secretary of the PWD on 16th of this month. The same is not connected to the case record. So, Mr. Das on the other end submits that copies have been served on it. We would also like to file a rejoinder affidavit where allowed. Released after 3 weeks of registry will also verify and connect the said affidavit stated to be filed with the PWD, the case records. File your rejoinder, then we'll fix a date.
This is regarding payment of gratuity, lordship. Petitioner's husband, lordship, worked for more than 27 years and as master of lordship. Thereafter, lordship, he expired. Petitioner submitted application, lordship. That was forwarded also. And
Why gratuity not granted?
lordship on,
My lord, we have filed an affidavit. I think
yes.
the receipt, if they want to reply, my lord, fine. Otherwise,
Lordship, they are saying that since petitioner is not work just employee, master role, but she is not, her
Yeah,
husband,
entitled.
eligible, entitled, lordship. Lordship may kindly see rule 153
Oh,
of Assam pension, some service pension
153.
153, lordship. 153(2) is regarding work charge employee, 153(1), lordship. In my book, it is 197, 96 page.
153.
53(1), lordship.
Please read.
The governor of Assam may, at his discretion and subject to such condition as he may think fit to impose, grant gratuity not exceeding 6 months pay to a person who retires after rendering many years of satisfactory service as a contingency employee or in different porter corps or in any other non-pensionable service within bracket, lordship, other than members of work charge establishment, provided that no retirement benefit is otherwise admissible to such person under any specific rule or other applicable to him. Nothing was given to me, lordship. And lordship, discrimination is also there. Last page of my petition, lordship, page number 29, one similarly situated person, lordship, was given. Others they are giving, but discrimination with me, lordship. Page number 29, lordship, same similarly situated casual master role worker, lordship. She was given, lordship. And my husband worked for 27 years, 3 months, 6 days.
This is not proper, Mr. Dhar.
my lord, this person is not before your lordship, my lord. This Kamini Boro, they are not made a party.
You know, they have no claim against Kamini Board.
No, we
They
don't
want the same benefit.
Yes. And this is their order
It is for
only,
you to
lordship.
decide.
My lord, the thing is that when the matter initially came up, my lord, it was only on, I had to take a very small instruction, my lord, that why it was not paid. We only came up with that instruction only, my lord. So my lord will grant me further time, my lord. I will get parawise comment of the entire writ petition and file an affidavit, my lord.
So why did you file an affidavit?
No, my lord,
Already they have filed, lordship.
my lord's direction was that why very limited time was given to me only on this particular issue. Why gratuity is not released? Only this. So I got this instruction in my lord.
Notice was issued on 10/12 of 2025, lordship. Thereafter, today is 17/6. Sufficient time was there, lord. Our husband worked for 27 years.
Learned counsel of parties. Generally agree that gratuity is payable. Other similarly situated master role workers has not been released respect of the services rendered by the late husband is also a must do worker. So, the counsel for the petitioner has referred to chapter 10 of the petition to submit that a similar situated master road worker was sanctioned the gratuity by the department, whereas differential treatment is meted out to the husband of the petitioner, although husband services as the master road. So, further referring to Rule 153. 1 of the Assam Services Pension Rule, it is submitted that there is a provision for grant of gratuity to contingent employees rendering satisfactory service, provided no other retirement benefit is otherwise admissible to such persons. So, petitioner is claiming benefit under this 153(1), which it is submitted, has been released in respect of other similarly situated candidates, an instance of which is referred to in Lecture 10. There are Mr. Dhor submits that this aspect he would like to complete his instructions, prays for 3 weeks' time. Prayer made is allowed. The respondents will endeavor to apprise the court with regard to the claims made by the petitioner on the next returnable dates, released again after 3 weeks on a date to be fixed by the registry.
The date may be fixed, Lordship. Only this hope is only, petitioner has this only hope, Lordship, only this month. That is why a date may be fixed, Lordship.
29th of July.
43.
That is lost. But here, the petitioner, he is a constable, my lord, and his first wife deserted him, my lord, in 2018. In 19, my lord, he performed second marriage. And on the basis of a government official memorandum, my lord, issued on 2010 2023, my lord, departmental proceeding was initiated for performing second marriage. And finally, he has been dismissed.
There is division bench judgment.
Yes, Lord, we have.
Who's for the respondents?
Lordship, I am again for the respondent.
Dismissing for bigamous
Lordship.
You lost
conduct.
your
But are you familiar with the orders?
No,
passed?
Lordship, I shall go through this, Lord. Lordship may take it up after
Monday,
the vacate.
Monday. Tuesday.
Tuesday, Lordship.
Based on 23rd.
Lordship.
Enabling the respondents to apprise the court as to the judgments rendered by division bench in similar matters as placed by the Learned Counsel. Released on 23rd.
Lordship.
23rd.
Deeply obliged.
Lordship, here the petitioner has been rejected by the review medical board despite his disease is not enlisted in their guidelines, Lordship.
What is the rejection?
Lordship, your Lordship will find at page 32 of the writ petition.
Yes.
Lordship, DME said reason for medical unfitness, penile vitiligo. Then he applied for review medical board.
Unfit.
Lordship, reason for medical unfitness is penile vitiligo. Then the review medical examination finding was discolorization over shaft of penis present. Specialist opinion taken from Silsor Medical College. Then attached report attached as candidate made unfit as per recruitment guidelines. Lordship, they have filed their affidavit in opposition wherein they have attached the report, Lordship. That your Lordship will find at page 51.
What is the guideline? Is there
Guideline, Lordship, general guidelines.
6, general guidelines for rejection, Lordship at 19, your Lordship will find it chronic skin disease like vitiligo. Vitiligo is
Yes.
present,
Yes,
but leukoderma is not mentioned.
page 54, Lordship. Yes, 54.
That is the guideline, Lordship.
This one, guideline.
Yes.
It is also annexed in page 54 of our affidavit. 11.
Of your affidavit.
Yes, sir. 11.
Yes, Lord, yes, Lord. That is
General grounds for
general
rejection.
grounds for rejection at 19. 619.
Hmm.
Chronic skin disease like vitiligo. Vitiligo is mentioned, Lord. Their detailed medical examination said it was vitiligo, but when specialist opinion was taken from Silchar Medical College, Lordship, they said it's leukoderma. Now, leukoderma and vitiligo are not synonymous terms, Lordship.
Says who?
That otherwise it would have mentioned, Lordship. Vitiligo and leukoderma are not same, Lordship.
How do you, from what basis are you saying that?
Vitiligo is a chronic disease, Lordship.
Is it from your own understanding or are you relying on some authorities?
If I can bring on the next.
It's up to you, because here
Otherwise, also, Lordship.
court will not have, the court is not equipped with
Lordship.
any
I understand.
apparatus or standards to understand which is what.
Otherwise, also, sir, Lordship, the report of the GMCH that says, Lordship, at page 33 and 34, after the rejection, the approach.
What about the records?
Record.
Medical records?
Specialist opinion is attached.
Lordship, I produce on an exit.
Where is the medical GMCH report?
The report is at page 33, 34 of the repetition, Lordship. Page 33 is the typed copy. Page
33.
34 is the original copy. That is also legible, Lordship. Lordship, may I read? An atrophic sear present over coronal sulcus. Patient does not have any sign of any acute or chronic illness at present. Patient is physically fit to perform regular physical activities. The lesion is not suggestive of vitiligo or leukoderma. That was issued by Registrar of Department of Dermatology and STD, Gauhati Medical College Hospital.
Then where is that?
Specialist opinion, Lordship.
But there is the specialist opinion taken from the Silchar.
Silchar, yes, Lordship. If may I read that, Lordship?
At page 54 of our affidavit.
Page 52. This lesion has been examined properly. It is non-contagious. The lesion will not hamper his day-to-day activities and will not be a hindrance to his performance in duties assigned to him.
It's stated that it is not vitiligo or
It said in the at page
Leukoderma.
51, leukoderma over shaft of penis. Since the report of the detailed medical examination was before the specialist, Lordship, he has seen that this petitioner was rejected on the ground of vitiligo, and he does not mention vitiligo in the report, Lordship. He mentions leukoderma over shaft of penis.
Not like this. Can't reopen every medical case. Mandate. Must make out a case that these documents were also placed before the civil authorities. No. These medical reports of the DME and all,
Yes,
was it available to you?
Not the specialist opinion, Lordship. Specialist opinion they brings on record after a order by this honorable court, Lordship.
Do you furnish medical records?
No. They don't
Then-
furnish us.
Then how do they find out? Your opinion of the DME RME is final and you have these opinions in the absence of the concerned specialist. Was there a dermatologist present?
Concerned specialist was never.
Lordship, the opinion of the dermatologist, specialist dermatologist in Silchar Medical College has been taken
No, but
by the review medical board, Lordship.
no, but was he a member of the review medical? Was he requested to be present in the review medical? No.
So as per the guideline, the review medical court can see
You have
the opinion, Lordship.
you have taken, where is the review, where is the report of the Silchar medical?
At page 51.
51.
It starts from 51.
51.
See, it has been held to be not contagious
Not
and not hamper
is
the day-to-day work.
It is, yes, Lordship. It is general report, Lordship. It is, but it is a chronic skin disease, Lordship. In our affidavit, it is
Then
stated.
why have you taken into consideration this report?
why the specific query that whether it is a skin disease or not will have to be referred. The purpose of sending it for specialized report is to find out whether your queries are answered or not. It has not been done.
But he has a leukoderma lordship. As per our
Leukoderma is not mentioned in the guideline, lordship.
lordship, as per our affidavit, leukoderma, white depigmented skin is also chronic skin diseases like vitiligo.
Is it mentioned in the guideline? That is important, lordship. It's not.
The margin of probability in your favor is less because of the disputed questions of fact. One specialist is saying one thing, another specialist is saying another thing.
Lordship, if I may please, the detailed medical examination, they do not have any specialist. So far, I know.
They are not
It is just
required
general
to,
doctors. They say it is
They are
penile
not-
vitiligo.
they are not required to under the rules.
Right, lordship. But
You have submitted to the DME RME,
RME.
knowing fully well that there is no specialist medical.
No, RME, since they did not have, they themselves took the petitioner to a specialist in Silsar Medical College as per guidelines. The specialist opines that
Specialist opines everything, but does not opine whether you suffer from that particular condition or not.
that means I do not suffer,
No,
lordship.
that inference is not available. Either you have it or you don't have it. They have decided or they have comfortably not addressed this issue.
Then
So
let there
therefore
be
it goes both
another-
ways.
Let there be another review medical.
Why should there be?
Lordship,
Why should we
there is-
reopen every medical
But there is already interim order passed by this honorable court for a
saying what?
to keep
Saying
a
what?
post vacant. To keep a post vacant.
Post will be vacant, but
And there is an order of this honorable court, lordship. We have annexed one, and there is an order in a similar matter, lordship.
are you agreeable for a review medical board with a proper specialist?
Lordship, as per page 65, lordship, as per the guideline of review medical board, lordship, at page 65. Lordship, if I can see page 65, 6B, lordship. Review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. Therefore, in cases of rejection in review medical examination, clinical findings should be corroborated with confirmatory test, investigation, opinion of a specialist, super specialist of government hospitals, medical, government approved.
So you have referred to Silchar Medical, they
Yes,
have given a
Lordship.
report in
Yes,
5150.
Yeah, yes.
Does this report say that he is unfit for duties?
No, it does not say. It's not in conformity.
Illegal does not make the person unfit for duties, but it is a ground of
First, he-
rejection, lordship.
Huh?
It is a ground for rejection
How
of the
this ground,
candidacy.
it is said it is non-contagious, will not hamper his duty activities. You have taken a part of the opinion, you have rejected the other part of the opinion. Either you accept in whole or you reject in whole.
Lordship, with the grounds of rejection as per the guideline of 2015, lordship, page 54. It is a chronic skin disease, lordship.
Lordship,
Chronic skin disease is not contagious.
Chronic skin diseases like vitiligo, leprosy, in no way said that it should be contagious, lordship.
Who is the review medical board? Who is in charge of your review medical boards? Should we call him to court and give an explanation how these are to be done? Is it available to them to twist or accept things which are acceptable to them, reject things which are not acceptable to them? Either you accept the medical opinion or you don't accept.
Yes, lordship, as per
You have accepted part of it.
lordship, as per the
What is the meaning ascribed to the medical opinion given by a medical expert that this has been examined, it is non-contagious. It will not hamper his day-to-day activities. It will not be a hindrance to his performance and duties assigned. How can you ignore this?
But lordship, as per the general grounds of rejection, it is not required to be contagious. It is a chronic skin disease.
Has he explained that it is a chronic skin disease?
Yes, lordship.
Where?
In the affidavit, it is said that.
No, forget
Has
your
the
affidavit. In the opinion of the doctor,
page 51 of the book.
heard counsel for parties. The petitioner is agreed by the rejection of his candidature by the DME RME on the ground that he suffers from a chronic skin disease. Stop. The department, after the opinion of the RM, after examination by the RME, referred him for opinion before the Silchar Medical College, before the specialist, dermatologist. Stop. The dermatologist had given the following opinion, page 52. Stop. The case of the petitioner was still not reconsidered by the RME on the ground that the review medical board, on the ground that the medical opinion did not rule out vitiligo.
Response.
So, on the other hand, counsel for the petitioner has also placed before the court the opinion of a civilian doctor and a specialist in dermatology. Where is your opinion?
My opinion is at lordship at page 33. Type copy 34 is the original.
Where it says that the patient does not have any signs of acute or chronic illness and is physically fit to perform regular duties, and that the lesion is not suggestive of vitiligo or LEU.
Leukoderma.
Leukoderma. Stop. The what appears to the court is that the review medical has taken the opinion of the specialist rendered in the Silchar Medical Hospital. Interpret that the petitioner is not fit for rendering his service in view of there being no finding that the petitioner does not have chronic skin disease. So, this interpretation, according to the court, upon a plain reading of the medical opinion, cannot be accepted. So, the review medical board will either have to accept the opinion in full or reject it. Stop. It cannot be permitted to accept part of the opinion and further go for a further interpretation of the opinion. Stop. If the queries put by the review medical board or the respondents before the specialist, civilian specialist is not answered, then either they will have to reject or issue a fresh proposal raising specific concerns to be answered by the civilian specialists. So, under such circumstances, on the question of the health status of the petitioner vis-a-vis the guidelines issued, this court remands the matter back to the review medical authority and to the respondents to reconstitute a review medical authority to re-examine the petitioner, taking into account the various medical certificates, medical opinions, and clinical findings that may be available. Stop. The review medical board will also consider presence of a dermatologist from a civilian hospital so that a proper opinion is rendered in respect of the writ petition. Stop. By order, earlier order dated 5/1/26, a post has been directed to be kept vacant. The post of Constable DDG, the CRPF, has been directed to be kept vacant. This interim order will operate till such final orders are issued by the review medical board as directed by this order. Stop. If the medical board on reconsideration, finds that the petitioner is capable of rendering services, then consequential process / orders will be passed for appointment of the lead petitioner. In the event the review medical board, upon re-evaluation as directed, finds that the petitioner is not capable of being appointed, no further orders are necessary. The interim order will cease to have any effect. Let this exercise be completed within a period of 30 days. 30 days from the date of receipt of a certified copy of this order. As directed, interim order dated so and so will have effect till such date, till 30 days from the date of receipt of a certified copy of this order, or till such orders are passed to the review medical, whichever is earlier. Yes, please. Yes.